Second,
Lozima matter means what? What is relating to what?
second appeal,
Second-
the appellant hasn't submitted any talvana. That is why the matter was enlisted in the registered logima, and the registered logima just transferred the matter into court logima. That is why I am praying this matter to enlist.
Give.
My-
Give.
My lord, for inclusion in your lordship's list for hearing matters, my lord. But on 24th, my lord,
Able to touch not even a single one.
my lord, kindly appreciate, my lord, 24th of June, Mr. Somu Majumdar has mentioned your lordship.
Maybe. There is no charm in the name so far as this court is concerned.
But there is some urgency, my lord, kindly
What
appreciate.
urgency? Of which year?
My 2023, my lord.
Yes.
The
So what
matter
is an
ready, my lord.
urgency?
The Honorable Single Bench has cancelled the 32,000 candidature of the assistant primary teachers, my lord. But they are enjoying the interim order passed by the erstwhile bench, my lord. My lord, matter, the affidavit has been exchanged in the meantime, my lord.
Application give. Let us see.
My lord, grateful.
My lord,
Lordship, may I be permitted to
I am filing my lord দুইটা certified copy server copy
Okay.
10 June my lord.
Today is 8. Have you applied for certified copy?
Yes lordship.
Have you annexed the photocopy?
Yes.
Lordship, may I be permitted to mention this is a hearing matter. There is a Honorable Supreme Court's direction to hear out the matter expeditiously.
When the direction was passed,
That direction was passed in
7
7 July 2023.
what you were doing?
Lordship,
there
this
were
is the
other
matter
benches,
in the previous bench, the hearing was going on. Since
and
the
then let it
determination,
go on.
Lordship, this regarding the primary teachers.
Whatever,
those-
then let it go on. They have substantially heard the matter.
Lordship, the determination has changed subsequently.
Hey, for release, the other to be mentioned.
May I permitted
It has substantially heard. Let it go there. Yes.
permitted
I'm
to
great.
mention my lord, for inclusion in the list as the application, my lord, group two.
Application. Yes.
Lordship, may I be permitted to mention your lordship for inclusion, your lordship?
What?
Application, your lordship.
All application.
Number one.
I am for the typographical mistake SAT 2023 it has been 2024
নন্দী জীবনে আর কেউ ভুল করতে পারে না এই
Number two.
Lord, I appear for the appellants in this matter, my lord.
what you have not done.
My lord, it was dismissed for default, the appeal, in the year 2006. The records are staring at my face. I will be very candid to your lordships. My lord, the restoration application was filed in the year 2010. There was no application seeking delay in that. There, my lord, but the Lozima court, while dismissing this appeal, was kind enough, my lord, to make an observation that since requisites was not filed on the respondents, hence the appeal was dismissed.
To be dismissed, then what to do? If you slept over your right, then what the court you
My lord,
expect that the court
unfortunate,
should do?
my lord, the unfortunate part is, my lord, appeal.
Unfortunate.
My lord, our client's unfortunate part, my lord, and the appeal was 1991. It was a rule was issued. There was an order of stay till the disposal. My lord, unfortunately, that entire thing has happened. My lord, in the meantime, everybody.
Unfortunately happened. The Lozima court, so many times the matter appeared
Yes.
before the Lozima court.
That
You
is the
do
reason
not-
I
do
at
not
the outset
care
at
that
the
what
outset I said, my lord, the
Remand.
records are staring at our face, at my
has
face.
to be.
And my lord, in the meantime, all the respondents had died.
Here
We
we will be allowing and then with cost.
My lord, as your lordship
Yes,
pleases.
at least some
My lord-
strong message must go.
My lord, in the meantime, my lord, everybody has, my lord, all the respondents had died. My lord, we had tried to take out applications for substitution. My lord, in the meantime, I would like to draw your lordship's kind attention to a fact, my lord. The present appellant was murdered by the respondent number 1, in which, my lord, the present appellants, my lord, the respondent number 1 and his sons were in custody. Still now, one son is in custody for the life. And the entire property, we are in possession of the property.
You are the heirs of the appellant.
Yes. and we have, my lord, tried to serve them. Till now, my lord, we have 4 affidavit of services. Out of the present income, my lord, new proposed respondents, there are 40 of them. 15 of the envelopes have returned as refused, and the rest have received it.
You have not taken out an application. You have taken out an application after the limitation. There is no prayer for setting aside abatement.
My lord, we at this point of time, my lord, at this very moment also, we are not aware of the date exactly, my lord, when they have,
You have to ascertain.
my lord,
There must be a record, public record for that.
my lord, we are, my lord, as I
So
have
we'll
said,
have to, leave is granted to the applicants to file the supplementary affidavit within 3 weeks from date.
may I file a affidavit of services of these matters?
Not necessary, you come on that day.
Grateful, my lord.
Item number 3.
For the appellant. Since my appeal, there is an application for substitution. Well, not really substitution, it is for recording the death of the some of the respondents.
Only opposite party number 1 you have taken out.
Opposite party
Some of the
number 1,
respondents, how can you, this is the prayer at page 4, opposite party number 1, can
Lord.
7.
Lordship. All the opposite party, there is a typographical error, my lord. This should have been 11. If Lordship wants, I can file afresh.
Leave is granted to the applicant to file supplementary affidavit within a week from date.
Lordship has kept it, Lordship.
1 week time is given to you.
Item number 4 and 5.
4-5, my lord.
Yeah, for the respondent number 1 and 4, my lord.
Yes, unique point.
Noxious. Lordships, the last occasion, if I may, my lord, respectfully recapitulate, I cited one judgment.
No, not your judgment. You cited one judgment.
I cited one judgment, Lordship.
You said, I cited my judgment. That's why.
Sorry, how can it?
Yes, that is a Kedarnath Rajgori Charitable Trust,
Lordship,
2004, volume 12, SCC, page 425.
so this judgment I cited, it was working in my favor, but
Do you think it is working in your favor?
it was, my lord, but it went passed by a whisker and went against me, as because this section 7 of 1948 suffered an amendment in the year 1996.
And we noticed.
When this 23(1) and 1A was inserted by Amendment Act of 1996. But that was given if
Act 1. Yes.
but that Willard Amendment Act of 25 of 1996, by which it was inserted, it was having some retrospective effect, with effect from 1994, 1st April. And Willard, our Section 4 notification was on 3rd June 1994. So that amendment of Section 7 was given effect from 1st April 1996. So it's passed by a fiscal lordship. Because Section 4 is 3rd June 1994. And section 7 that amendment was given effect to on and from 1st April 1994.
1994.
1st April 1994.
Correct. And you were, if I remember, 4th January. Notification under section 4.
Lordships, may I respectfully, my lord, invite my lord to paragraph 7 of the judgment I cited.
No. Actually, let us see.
Section 7 suffered, underwent an amendment.
Oh, I understand, sir. Your notification under section 4 was when?
That was on 3rd June 1994.
So after the amendment is taken effect too, so what remained?
So, my lord, it passed by lordship.
So what remained?
That is why, my lord, it was working in my favor, but for a slightest chance, my lord, it passed by. Because effect was given from 1st April 1994.
Understand. Then that amended provision will apply.
So 23(1)(a) he was entitled to, which
Correct.
was not given by the state.
Correct.
So no quarrel on that issue. 9% term, 15% term, no quarrel on the issue. But so far as this rental compensation, state had given him 6% term, learned judge has given him 9% term. So, my lord, now the only bonum contention which remains.
Now, only thing is, if there is any parameter, if there is any evidence in this regard, that
I could not
that-
find out.
that is, then it is left to the discretion.
Lordship.
If the discretion appears to be rational, reasonable, cannot be impinged, then why the appellate court will interfere with the discretionary order?
But my lord, my argument, my respectful argument, my lord, goes to the root of the matter as to how the the market value, my lord, was, my lord, arrived at. If your lordship may kindly, my lord, recall, my lord, the impugned judgment.
Very cryptic.
Lordship, that appreciation part, which, my lord, I was, my lord, trying to, my lord, and I indeed, my lord, drew your lordship's, my lord, attention. If your lordship's, my lord, if I may respectfully invite your lordship's, my lord, to page 8 of the paper book.
We are looking at it.
So, my lord, 65% term appreciation, and so far the second part, 20% appreciation. So, in my respectful submission, this armchair assessment, my lord, was without any basis. If I may respectfully, my lord, cite some judgments on this point, lordship. So, what are the factors?
Sir, there are two aspects in a first appeal. When you argue a first appeal, it is not like any other proceedings where you can rely on any documents, because we have to concentrate on the basis of the documents which were exhibited in the trial court. We will not travel beyond those exhibited.
But LCR is missing, unfortunate part of this.
Now question is that the LCR is missing. Now, what was the document which was there before the court? That is all we are lacking, but there is a reference in the judgment that there was one exhibit. That is an exhibit 1, which according to the judge is the sale deeds, comparable sale deeds. Now,
And on the part of the state, rate report.
correct. So, what would be the safest mode of calculating the market value? Comparable sale deed or the rate report the state of his own has produced? What should be the best piece of evidence for that?
My lord, best piece of evidence, my lord, to reach or to arrive at the market value. My lord, the yardstick which has been, my lord, followed by the learned judge is, my lord, if I am to borrow the term used by this honorable court and also upheld by the honorable Supreme Court, the armchair assessment.
No.
So
Sir,
learned judge has
I'm
made
telling you,
armchair assessment.
no, armchair assessment, I have certain doubts. I have certain doubts. You are talking about the armchair assessment. We will definitely look into those line of judgments. Armchair theory or the doctrine of armchair originated much earlier point of time when this land acquisition was also not there. It was the brainchild of Lord Denning. And it was introduced while interpreting the terms and the language used in the will.
Will, lordship, lordship,
Then the question of armchair theory that comes.
lordship, lordship.
You can, this is not an armchair theory. In a land acquisition, what I understand, it's a arm length distance theory is to be considered.
At an arm's length.
It is an arm's length theory or the doctrine, not armchair doctrine. That is what I was thinking. One property which is at the arm's length and there is a comparable sale deed that comes, that's the safest mode of ascertaining the value.
But Milord, here, if the exhibits, Milord, we are to deed as sale deeds, it related to which premises? That is also, Milord, opaque. It's not clear. But so far as our
Juniors, let me some academic discussion. on-
lordship, 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 lordship. What is appreciation part, Lordship? Learned judge is just going in,
Sir, when the record is lost, what to,
so Lordship, at least, my lord, this 65 appreciation, 65% and 25.
game, that is that evidence of the gentleman. You have not denied what they have said in the evidence. Where is that evidence? One page.
My lord, that is a supplementary, my lord.
Supplementary.
এরম ভাবে দেওয়া আছে।
Since I admitted that it is true that
তারপরে
the
সঙ্গে তো
acquired
আমরা কালকে
land
থেকে ঢুকছি।
surrounded by a developed land, acquired land is itself a developed one. The locality enjoys all the amenities of modern life,
My lord, in the rate report also he said the same thing.
such as the underground sewerage, school, college, market, supermarket, hospital, nursing homes, cinema halls, lake, etc. in the vicinity. The acquired property has got a wide frontage of about 60 feet road and equally wide back frontage of 20 feet road. Says that the said plot of land may be an ideal plot for construction of a multi-storied building. That is for evidence.
If your lordship, my lord, kindly sees our rate report, we have mentioned the same thing, lordship.
That the deed is the best piece of evidence. Then a comparable selling.
Now, lordship, my first respectful summation would be this,
I do not want to.
my lord, 65% and 20% appreciation on what basis, my lord? On what yardstick? If I may, my lord, on this, my lord, according to me, is without any basis. And in this context, if I may be allowed to cite one judgment, lordship.
In a report also, why you have given an appreciation. You have also given an appreciation.
Lordships.
Why you have given an appreciation.
Kindly sees at page 25, my lord, of the paper book. This is a rate report. All the sale data was also taken into consideration.
Why you are giving come to page 626
26, lordship.
at the bottom? Why you are giving
Appreciation and depreciation.
appreciation? 5% rise may be allowed for the location. 10% rise may be allowed for the instance. But 2.5% depreciation may be allowed. 30% rise may also be allowed for difference of the year. Why? Means you were aware that there is an appreciation. That's your own.
So, my lord, since they were comparing with another my lord property,
Anyhow.
no, you'll There is no discussion, my lord. My lord, as my learned just as a settled principle, comparability, proximity, just he goes on, my lord, using the words and phrases, and just he comes to this, my lord. My lord, if I may, my lord, cite, my lord, some judgments, lordship. Two 2003, my lord, SCC online. It's a division bench judgment, lordship. Uh-huh. 2003 SEC online. Cal 50. Lots of argument in last touch. It's on the proposition, my lord, armchair assessment. If I may, my lord, respectfully, my lord, read out, my lord, certain paragraphs. If I may read out, lordship. Para 2. We dispose of this by common judgment and order 3 appeals from a common judgment, so and so. Para 2. The acquisition in this case did not take place under Act 1 of 1894, but under the West Bengal Act 2 of 1948, which is called the West Bengal Acquisition in 1948. Para 4, my lord. The number of referring claims is quite large and is above 20. They are in 3 sets. The land was acquired under Act 2 in May 1995. The area is upwards of 3 bighas. 1 bighas is 20 kathas and 1 katha is 720 square feet. The land was a part of a 10 bigha tract situated at 156A Maniktola Main Road, owned previously by a single common ancestor, namely Kalipodo Barik, since deceased. The collector made this award sometimes in the year 1997, and thereafter the land acquisition judge was approached on reference by the Bariks. The collector's award was on the basis of about 50,000 rupees compensation per katha, but the land acquisition judge on the first hearing raised it to nearly 5 lakh per katha. Now, my lord, here what happened? The fact is that the government gave 50,000, the reference court, my lord, gave 5 lakh per katha. Honorable High Court reduced it to 2.25 lakh. That will appear from paragraph 84. Now, my lord, be that as it may I read out paragraph 9. Be that as it may, the requiring authority, which in this case would have to pay the money ultimately, being dissatisfied with the land acquisition judge's assessment or compensation, file a writ application in the High Court at Calcutta, complaining against the matter being finalized in their absence. On the 3rd May, so an order was passed by Division Bench High Court, whereby the matter was remitted to the land acquisition judge, directing the CAC to be made a party. It was also directed the parties who had already been examined before the land acquisition judge would be again presented for cross-examination by the CAC subject to the availability. Thus, the matter was heard on remittance. Now, my lord, if I may respectfully invite your lordships, my lord, to paragraph 28. Para 28, lordship. Regarding the basic price of the land per katha, 2 pieces of property were brought into evidence by the Bariks. One was another plot at Naniktola Main Road itself, and that was sold for rupees 23 lakh sometimes in 1994. The agreement for sale in regard to that property was some 4 years older than the conveyance, but that was not exhibited, and the land was 5 katha only, and the land price came to about rupees 4.60 lakh per katha. Mr. Dash, appearing for the Bariks, submitted that we should further increase this price, since some rupees 18 lakh out of this aggregate amount was paid earlier than the date of conveyance, but we are not minded to enter into that exact calculation. Now, paragraph 30. Another plot of land was 73 Bagmari Road. This was also a plot of land in the vicinity, but there was a talk of a acquisition of this land also. It was requisitioned, but ultimately not acquired. The rent compensation during the period of requisition required the fixation of land value for calculation of the rent compensation as a percentage of it. This part of the land value assessment is still sub judice before the High Court from a reference judgment. Para 31, my lord. We take note, therefore, of both the facts. The land price of 73 Bagmari, as shown by the Bariks, about the material date is above rupees 5 lakh per kata, and that is still sub judice before the High Court in another proceeding. My lord, here one of the contentions taken was that state had taken one rate report of a property of this Beliaghata, which is sub judice, the award of which is sub judice. Now, my lord, may I specifically 33, my lord. It is also the law that one should attempt to find a lordship. 32, my lord. Mr. Das, learned counsel.
You borrowed this armchair, this one from 1995 Supreme Court judgment. And
Lordship.
the judge has clarified this position that armchair in 47 and 48 also, which I said.
Lordship.
Paragraph
Lordship.
47 and 48.
Lordship.
But I don't think so that it is a appropriate one. We have to look at 1995 Supreme Court.
1995, 5 SCC, Lordship.
I do not know. K. Posaya's judgment.
Lordship. In 33 also it has been referred to in paragraph 33, Lord.
But paragraph 34 is a correct reflection.
Now, I will refer to that, Lordship. Lordship.
34 is a correct reflection. I'm a fast reader, that's why I'm saying. I have already read.
So,
up
my
to
lord,
paragraph.
if your Lordship, my lord, may I just refer to the paragraphs that we would like to refer?
Please, because I have already read up to paragraph 51.
Lordship, paragraph 28, 30, 31, 32, 33, 34.
Oh.
36, 39, 36, 37, 38, 39. My lord, 41 to 47. 48 relates to how this armchair concept has come, as your lordship, my lord, were telling. And thereafter, my lord, paragraph 53. Paragraph 54, where the factors to be taken into consideration have been stated. That is paragraph 55, size of the land. Paragraph 61, whether the land is landlocked. Para 62, no sentimental factor. Para 63, reasonableness. Para 68, road frontage. Para 72, belting method. Para 79, type of land. Para 82, common sense approach.
Sir, there has been a lot of development, lot of changes that has been brought in the concept.
My lord, this has been upheld by the Honorable Supreme Court.
No. After that, how?
2008.
The SLP was not admitted.
No, my lord, in 2008 it was admitted, and it is reported judgment. This went up to Supreme Court.
Thereafter, much have flown in the meantime.
My lord, may I, my lord, place this 2008-17, my lord? Honorable Apex Court has been pleased to upheld this judgment so far as the process of assessment is concerned. 8-17 SCC 436. If I may respectfully invite your lordships, my lord, to paragraph 22. We do not find any infirmity in the approach of the High Court. Therefore, the rate fixed by the High Court does not suffer from infirmity. The appeals filed by the appellants is therefore stands dismissed. So this was this my lord, procedure, my lord, was upheld by the Honorable Apex Court. But on the point of rate of interest, Honorable Apex Court deferred. That is at paragraph 25.
Yes.
Lordship, next judgment, my lord, if I may cite, my lord, is that here, my lord, our rate report was prepared by the surveyor and valuer. My lord, his, my lord, report, my lord, should not have been discarded summarily, because expert evidence, my lord, has importance in coming to the point of determining the market value. So, my lord, the rate report, my lord, which was exhibited and the witness examined, the rate report, my lord, has not been given any importance, any credence, my lord, by the learned judge. But this judgment says that in the matter of, my lord, determining the, my lord, the market value, expert evidence like that of the surveyor valuer should be given credence. So, my lord, if I may respectfully, my lord, cite this judgment, my lord, of a division bench of our honorable court, my lord, 2006, my lord, lordship. 2006 SSC Online Cal 577. My lord, if I may, my lord, rely upon, my lord, paragraphs 5 to 8, 22 to 30.
Yes.
Lordship, next judgment, my lord, if I may cite, my lord, that is of
You
1995.
are citing it consciously. This judgment of Justice Sengupta and Justice Banerjee, you are citing it consciously, going through it.
Lordship.
Yes, next.
Lordship's next judgment, my lord, on the proposition, my lord, that when ex parte valuers valuation is to be taken as a determining factor, even ignoring the sale deed. This is, my lord, (95)(5) basis, my lord, 233. Paragraphs, my lord, 2, 4. Paragraphs 2, 4, 6, and 7. Two, 4, 6, and 7.
Yes.
Lordships, the last judgment that I would like to cite on the proposition, how the market value is to be determined. Milord, 1994, Milord, 4 SCC 595. Milord, this judgment comprises 6 paragraphs. So, Milord, I would like to, Milord, rely upon this judgment.
Next session. Watch.
No, 1 to 6, entire judgment comprises 6 paragraphs only.
What is this judgment, sir? You were arguing against it when you wanted to cite a definition of a market value from the Stamp Act.
No, Lordship's second opinion
That's not, sir,
at para 5.
sir, that is the whole problem. Please read the judgment in this way. The Supreme Court has relied the earlier judgments, said that there are 3 best way of ascertaining the market value.
Lordship.
One is opinion of an expert.
Lordship.
The second is the price which the prudent seller, a prudent purchaser would pay to the prudent seller in
Lordship.
respect of a property. And the third one is the advantages and disadvantages of those properties surrounding it.
Lordship.
Supreme Court has said the second method is the best method.
Lordship.
So discarded the first expert opinion. discarded it. Says the second one is the price would be the price which the prudent seller, purchaser would pay to a prudent seller is the best method, best evidence.
So a price paid within the reasonable time.
Oh,
in
that is
bona
what I'm
fide-
saying. Supreme Court has discarded that opinion, expert opinion is not a best one.
That
Come
is
to-
first part. Paragraph
Oh.
5, my lord.
Please come to
Para
the
five.
paragraph 5. It
Dot
says
keep, dot
after noting all this from this particular
Therefore, it is settled law
Adinarayan,
that in
Adinarayan says, therefore, it is settled that in determining the market value, the court has to take into account either one or other three matters.
Lordship.
What are these three matters? Just above it.
Lordship.
Number one is opinion of expert. Number two is price paid within the reasonable time in bona fide transaction of a purchaser
Lordship.
acquired the land adjacent to the land and such. And three is the number of years of the purchase and actual or immediately prospective profits. That is surrounding one. Then the Supreme Court says the second one means the price paid within the reasonable time. That is a comparable sale deed is the best one.
Bona fide transactions. Lordship,
There is no evidence coming. You can't argue in air. What is the meaning of the word bona fide transactions? The very simple thing is, I am say A is the owner of, say, plot number 1. B is the owner of plot number 2. B wanted to sell. Who can give the best price is the A or C. Now, there may be a competition between C and A. Both wanted to purchase the plot B so that they can increase their size of the plot. A gives the highest price, which can't be the real price, but just to have that amenities. Market price may be 1,000, he has paid 5,000 rupees. Anyhow, by hook or crook, I want to buy B. This is where the bona fide transaction theory comes. That one may, to grab that, may inflate the price, may give something more. Secondly, in one of the judgment, very interesting one, that the comparable sale deed must be on the date of the notification or better would be prior thereto. When there was a large or mass acquisition of, say, the entire village, now this, you say the township is being created. Many villages are subsumed into it. One sale deed is done immediately after this notification in a close proximity of the notification, where they have shown the price of 5 lakhs. And then say it is a yardstick. That's the last judgment which is said. You can't. It is only for the purpose of this acquisition, transaction has been done. Coterie, cartel has been created, one land transaction.
cartelization.
That cannot be. So that's why the bona fide transaction has to be considered in that perspective. One which comes prior to the notification. You can't think that there should be any inflation, provided if the purchaser is an adjacent plot holder, you can definitely raise that. It's not a bona fide, which the Supreme Court in one case says. You have to understand when you argue that what should be, the court has said this. It does not say expert opinion, definitely the last one. If there is none, in all these judgments you have cited about the expert opinion, there was nothing.
Our rate report, can we regard as
That is what I'm saying, nothing. Have you produced those deeds which you relied upon in your red report? No. Now I am going by your argument. If it is, how one will ascertain it was a bona fide transaction? The sale deed which you have relied upon. Tell us. The first and foremost, the fundamental thing is when you produce, the expert comes before the court and produces the report, he will produce all the documents which he has relied in his report. and to justify that what I have done
The
is the
entire
correct.
thing we has been done in a slipshod manner. Even your lordship,
And now there
your
is no,
lordships go by the memo of appeal.
there is no point of going back.
If your lordship go by the grounds in the appeal has been based on agreement for sale. But where exhibit shows sale deeds. So I should be a candid, my lord. So all these things have come, my lord, as a cut and dried to me, my lord. Whatever I get, I am just, my lord, trying to, my lord. Lordship, these are my, my lord.
Good. Sometimes the good cases are argued very nicely. Sometimes the bad cases are tried to be argued nicely.
But it's my feeble
You
attempt,
have,
my lord.
you have attempted anyhow.
It's my feeble attempt, my lord.
Because there is a very difficult task.
My feeble attempt, my lord, with your lordship, my lord, to argue this case, my lord, which I got cut and dried everything, lordship.
May I start tomorrow?
No, start it today.
Today? I need to consider all those judgments.
We have taken into consideration those judgments first time.
No, no, I would
And I was definitely, I must be very candid, this armchair assessment theory was not known to me, nor I have a lot of doubts on that.
Red report says when that particular officer who gave the evidence on behalf of the state before the LA judge, he got several sale deeds, but those were discarded because of the fact there was construction. And we are very much aware there is a term called guesstimation. Supreme Court has evolved this guesstimation term, where guesstimation is required. When you have one comparable sale deeds with a structure, you can get rid of the cost of the construction and you can get the value of the land. And you can rely on that value of the land. When belting method can be relied, when you have the comparable sale deeds, which is in a close proximity of the particular subject land, then that should be taken into consideration first, not the belting method. When belting method can be relied, when there is no comparable sale deeds. May I come back tomorrow? I'll be relying on.
He has already
Several
submitted a written
judgments.
argument. I think it was given to you
Yes.
much earlier.
Yes.
They have cited the same
I have
judgment,
prepared my written notes.
but they have cited the same judgment. You could have
May I be
gone through
handed
that
over a
judgment.
copy?
You could have gone through this. No, Mr. Dhar. Absolutely not expected.
I can start.
They handed over to you the written argument. They said that they will be relying on this judgment. Why you did not read those judgments?
Hmm.
You did not read those judgments. I think these judgments are there reflected.
It is there in the written notes of argument.
Yes.
আমার কপি নেই দাদা আমারটা দিতে হবে
My learned friend's argument I am getting just now. But
No, you are in reply. Let him first argue, sir.
so can he?
শেষ করে দিলে হয়। এই দেখুন 12টা জাজমেন্ট উনিও নিয়ে এসছে।
তোমারটা নেব
At the last page, he has given all these judgments reference.
yes
So why you did not read it earlier?
I read it I forgot it.
This matter was taken up last week. You had a full week with you.
This written notes of argument is filed by us.
Sir, you say their judgments I have to consider. That's why I am reacting to it. They gave you a prior notice. So that those days are gone when the appeals used to be heard several days, right from the plaint and then the written statement. Then those, now we are also coming after reading it prepared to some extent. Only thing is that you should argue. Just point out the main thing. This is not appreciated. Appeal for
kindly.
3 days, 4 days, and a small appeal like this. Should not take
I'm
more than-
not taking any time I'm doing it right now বাবা, এত কথা কি Kindly come to rate report, which is at page 25. Manad has got it.
Case 3, you are talking about the comparable state deal. And then you are talking.
My written notes of argument, my lord is, I'm sorry, my lord is referring my written notes of, yes. Which one, my lord?
Top one. The comparable state deed, then you talk about the agreement, exhibit 1. Copy of the agreement for sale deed, bill exhibits.
Oh, my lord, the copy of the sale deed. It should be copy of the sale deed.
Then why you have prepared it? So what is this? We have to take it as an agreement, what he was arguing.
But even I take it, my lord, if it is an agreement for sale. Supreme Court has said on 2 judgments, yes, that can be relied. Even a piece of paper where agreement is made not registered, Supreme Court has said it also can go into evidence and that can be taken as base for sale deeds. As if, yes, I'm relying 2 judgments where Supreme Court says even agreements for sale could be the basis of comparable value of that area. Worst case scenario, my lord, that's how, my lord, I have taken out those 2 judgments. One paragraph says even a piece of agreement which is not registered, even that can be relied.
Citing a judgment. Citing a judgment.
মেঘা আছে? আরে আমি ভুলে গেছি। সেটা বার করো তো। These are the 2. This is the judgment, my lord, where guesswork, then guesstimate, then guesstimation word has evolved by the Supreme Court. That is Trishala Jayan's case, very famous judgment, 2011, volume 6, SCC, page 47. আমাকে বলছে আমার কোনো না এগ্রিমেন্ট ফর সেলের যে দুখানা, আরে এগ্রিমেন্ট সেল ক্যান বি রিলায়েড এখানে রয়েছে। দেখো para 56, 63 and 64. ওটা কি ত্রিশালা জয়েন? না, আমি তো ত্রিশালা জয়েন দিলাম এস্টিমেশন। আমার বুঝতে পারছি না এটা না বুঝছো? আমার কাছে এসে এখানে এসে দাঁড়াও আমার এখান থেকে দেখতে থাকো 1991 এসএসসি 5-10 দেখো তো ভুটো পাটা করবে না আস্তে আস্তে দেখো মন্ডল 75 দাদাকে বলো 13 which paragraph you were relying upon 63 64 the collector or the authority land acquisition authority should have taken out the value of the cost of the construction of the other sale deeds which were available to them but they have discarded the entire all sale deeds and they went back to the belting method and they relied the belting method of the 14A that Beliagata main road property. দেখো না নেই এখানে কি এগ্রিমেন্ট ফর সেলটা পেলে আচ্ছা 91 আছে দেখো তো এখানে হাতের 2 এসএসসি টা আছে সাথে
May I take leave of your lordships? May I take leave of your lordships? Learned junior is here.
That is your reply. That's it.
এর না কি করছে Therefore, now, my lord, next judgment I would be relying. The learned judge should not have averaged out Meherlal Khewaji Trust. 2012 5 SCC 432. On the proposition, the highest value should be taken into consideration. I placed two deeds before the
Judgment in another case.
paragraph 8, 18 to 20, 23 and 27. আপত্তিও নেই সেল ডিড এগ্রিমেন্ট ফর সেল পেলে না কোথাও এর সাথে দুইটা দেখো তো Now, my lord, kindly come to the judgment passed by the LA judge where two sale deeds, my lord, one is 6,53,000 দুইজনে না? 2005 volume 2. দেখে নাও, দুটো বসে দেখে নাও। Now, my lord, next judgment, my lord, which I wanted to rely regarding the relying of a agreement for sale. That is 2005, volume 10 SCC, page 478. এটা তো আমার কপি, জজ সাহেবকে দিতে হবে তো। আস্তে 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 আস্তে। ভলিউম 10 একটাই, এটা দিলে 2005, volume 10 SCC, 478. It's a very small judgment, my lord. State went up to against the High Court's judgment, taking this point that agreement for sale cannot be relied by the land loser claimant. The 1991, volume 4 SCC. দুটো। দাদা আচ্ছা আচ্ছা, সিনেমাটা দেখলে কি এটা কোর্ট ছাড়াও, তাই কি যেটা বলছি তো? তারপরেরটা দাও আমাকে, বলবান সিং এন্ড আদার্স নিয়েছি। এটা দেওয়ার পরে এটা দেখাবো, ওটা দেখালাম, তাতে দেখার others read that. Supreme Court says, yes, this can be relied. If there are no evidence, kindly come to para 5.
Read it very carefully by yourself, sir.
Having considered the submissions made on behalf of the parties, we are satisfied that the High Court was right and justified in fixing the compensation at the rate of 170 per square.
170.
Yes.
Evidence was 150 to 200. Then
In doing so, the High Court has, as is clear from the impugned order, considered in detail both documentary and the oral evidence.
both documentary and oral record. Then proceed.
It has also taken note of the admission made by the witness RW1 examined on behalf of the appellants RW1
But the other side, that would get there.
Yes. In his evidence has stated that the value of the acquired lands was between 150 to 200 per square yard at the relevant point of time. Learned counsel for the appellants pointed out that RW1 was not the land acquisition officer. He was only a junior assistant in the district supply office. Maybe the appellants cannot disown his statement having examined on their behalf. It is also not disputed that the lands acquired had potential value. Here we have a potential value that has been admitted.
Because it was 100 feet away from the collector's bungalow.
Mine is fully, they have admitted in the rate report as well as in the, including the development of commercial complex, and they are abutting 100-foot wide road. In our case, 60 feet in front, 20.
20 feet behind.
Yes. As regards the contentions made by the learned counsel for the appellants in respect of exhibits A6 and A7, that they ought not to have been relied upon by the High Court, it may be stated that those agreements were on a stamp paper and the witness had also been examined in respect of the same, and either on their genuineness or the consideration mentioned therein. There was no cross-examination on behalf of the appellant.
This is another, that once you have produced these documents have been taken into evidence, no cross-examination, deemed admissions. On that basis, it proceeds. Just about very
subject to cross-examination had not taken place on that.
most vital. Two things are there. One is it contains a stamp paper, stamp duty. What was concept about section 33 and 35 of the Stamp Act. It does not contain the requisite stamp duty cannot be exceeded in excess. Embargo, unless impounded. Care of that. Contains the stamp duty, everything was proved by it. Is there may be those persons have been brought to prove it.
Yes.
Who are the parties to an agreement. And then there was no cross-examination from their part.
My thing is, it's a registered document. In our case, it's absolutely a registered document. And
Talking about agreement for sale has been accepted, not in that sense. Not a proposition on that. The liability of a document.
then, my lord, I'll be relying on a judgment, my lord, 1991, volume 4, SCC 212. This is on the proposition where even if I do not, or the cross appellant did not file a cross objection, if the landlord or the land loser claimant is entitled under the statute, the interests they can claim. Yes. Yes. But I have given that.
What about the subsequent judgment of the Supreme Court after this? Justice Bhaganathi's judgment?
formation of link road to the new town, Bagaltok township. It is not disputed that the land under acquisition is adjacent to the land in civil appeal number such and such and other connected cases. The potential value of the land under acquisition in these appeals is the same as in the earlier cases. The reference court granted an appreciation of 10% for every subsequent year.
For the best way of ascertaining the market value is that if a property which is the subject matter of the appeal is acquired by virtue of a notification which includes a lot of other property. One of the property, the compensation has been determined and reached finality. That's the best piece of evidence one can go into. Where the 10% application was accepted by the state. That's why the apex court says we are not going to disturb it because that has already been done. But not a uniform rule that it has to be done.
Well, I have, on this point, I have other judgments as also, my lord, where it shows minimum 10% appreciation one should expect. If there is no comparable sale deed just prior to issuance of the notification of land acquisition, if somebody catch hold of 2 years back comparable sale deeds, then for every year 10% would be the appreciation value. Then that matches with the date of the notification, issuance of the notification. এটা কত দিলাম 2 এর 3 আর হুম 12-5 দিয়ে দিই 16-13 দিয়ে দিয়েছি 2002-3 দিয়ে দিয়েছি মোটামুটি সবই দিয়ে দিয়েছি আর তো কিছু নেই না 5-4টা কি Mr. Galib has not taken the point of deduction for the purpose of development because it's already developed. So I'll not rely on that, and largeness, smallness has not also been taken. So this is a 23 kathas of land. So largeness concept won't come into play. This is my submission, my lord. Now, my lord, kindly come to my court, where, my lord, I have shown I have taken few grounds regarding the averaging out by the LA judge, which has come to 2,50,000 per katha. If there were two valuations in front of the LA judge, one is 7 lakh per katha, another one is 6,50,000. That comes to 5,04,556 per katha. Even averaging out, I have relied that 2012 judgment, that is Khaja Trust, Meherji Khaja Trust, that land loser should get the highest value of the comparable sale deeds. And the next point, that 15% from the date of possession on the market value, they are entitled. And belting method should not have been the proper way when their comparable sale deeds were there. And the proximity and regarding the this
Admission in their evidence. You can't argue. No.
yes.
all.
My lord, that's all. My lord, I am appearing on behalf of the two claimants and Mr.
Mr. Proneet Bagh is appearing for the respondent number 3, Your Lordship. My Lord, if kindly takes this matter after recess, Your Lordship. Lord, he is before some other courtroom, Your Lordship. Mr. Proneet Bagh is leading us, Your Lordship.
Since last week,
My Lord,
being from 10:30.
Lordship, he is before courtroom number 5, Your Lordship. He's Lordship, may I just, Your Lordship, in that case. Lord, we are any event adopting the submissions led by my senior, Your Lordship. And Your Lordship, the respondent number 3 is 83 years old, approximately. And Your Lordship, 48 years have been passed. So in any event, and her husband has also died. So in any event, Your Lordship, if the amount is not discharged, she will not be perhaps alive to enjoy the fruit, Lordship.
Well, we are hearing the appeal and we are so rigid,
Lordship.
I think, resilient on this that we are not granting you any time.
Lordship, may I
I apologize, my lord. I'll be very brief. The land in issue is, my lord, a land near Narkeldanga Main Road, prime property, my lord. This has been acquired, my lord, for providing accommodation to pavement hawkers. That was the original reason why this was, my lord, proceeded with. Notice issued under section 41A. My lord, Act 2 of 1948 invoked, my lord. This was gazetted in June 3, my lord, your lordship. Possession of property was taken in, my lord, 5th of May, on 5th of May 1976. Award was made on 20th February 1997. It is not pointed out by the appellant, my lord, that there is any discrepancy with regard to who should get the amount. It's only the quantum now.
See, when section 18 reference is given, then there is no difficulty. Had it not been a reference under section 18,
Lordship.
then I can understand that would be the difference.
It's not an issue at all. So, my lord, today, my lord, the 30, my lord, 30.
The entitlement will come.
Lordship. That's not under 18. Right? Today, my lord, the collector has assessed a value of 37 lakhs per acre, which is coming to roughly 61,000, my lord, 366 per kata. That's the figure. To which, my lord, the claimants raised an objection and hence the court proceeding. My lord. In the court proceeding, now with the backdrop, may I pause here for a moment? But with this, there's a backdrop, my lord, that all the, my lord, respondents in the proceeding, I'm, my lord, representing respondent number 3. The other respondents are, my lord, advanced septuagenarians and, my lord, they're approaching octogenarians. When the proceeding was ongoing, they were in their late 50s.
To change the law or
no, my lord, it is not. It is not with the law that I'm, my lord, making this submission. I'm prefacing my submission with this. The only reason is
submission for early disposal of the
indeed, my lord, because today my case is this. My lord, my case is this today. That today, my lord, there is a cross, my lord, objection which has been filed. Order 41, Rule 22 has been filed, my lord. Now today, that's not, my lord, filed by the respondent number 3, although we, my lord, end up to gain from that, my lord, outcome of the proceeding. But all that the reason why I'm making this submission is, my lord, today, whatever has been decided by the court, even if that is granted, half of it, my lord, is given. The balance, half of it is given, my lord, they will be, my lord, the respondent number 3 and the other respondents would be able to enjoy it for the rest of their life.
That's a question of the finality to a judgment and the question of disbursement through
my lord, that the only reason is this.
See that whether how it is.
My lord, then today, with the absence of the court records, my lord, I completely place reliance on the order, which is before your lordship. Although, my lord, we claimed, when we referred it to the court, we claimed 5 lakh per kata on an average. That was our claim. Now, if your lordship takes up, my lord, the paper book once, page 6 of the paper book,
That sets out the issue. I'm only referring to the judgment, which has been placed before your lordship.
Argued
Indeed, my lord.
Placed before us, the only thing is the argument which the appellant has advanced. What is your reaction to it? He has argued many things. They have argued many things.
But I'll fall back on the
They have argued, appellate have argued on 2 points, on 2 counts. First is that what should be the best way of ascertaining the market value. According to him, the armchair assessment is the best way of ascertaining it. He says that agreement for sale should not be considered. He says that the rate report which was submitted by the government or the expert that was there, the expert's report is the best piece of evidence that is to be considered. So he has argued that. Secondly, he has argued rent compensation. 6% they have calculated, 9% the court has calculated. What is the basis? So these are the 2 arguments which he has.
May I fall back on the judgment to refer to, my lord, the evidence which we had adduced in the proceeding. That's not before your lordship, but my lord, if it is not there before your lordship, then my lord, the order, since the order records the facts, that has a presumptive value, my lord. Today, if the documents on the basis of which the order is passed is not before the court, my lord, we have tried, that's not there. Rate report is before your lordships. Also, my lord, kindly note
that sale, suppose
in fact,
your agreement,
lordship,
whatever. But
lordship.
when the rate report is there, it has got a more sanctity over the sale. That is what he argued.
But my submission there is, my lord, the comparable deeds which we have given. My lord, if your lordship takes up page 8 once, there's exhibit 1. So now, your lordship will find this valuation is much more. This is 7.5 lakhs. I'm not even going by, my lord, whether this was.
Their argument is that suppose if there is a comparable sale deed, but there is a red report.
They say red report should be followed and comparable sale deed
followed.
Indeed, my lord.
Giving an edge over the comparable sale deed.
My submission is exactly the opposite. My submission is.
How? There must be a basis of those. Yes, I can many judgments on that.
But I'm not carrying the judgments today. But my lord, I kindly give me one day because my lord, the judgments, then I'll place the judgments. Yes, my lord. Then my lord, kindly permit me to indeed, my lord. I will not rely on any judgments. No, my lord, I'll not rely on any judgments. Kindly permit me to indicate this. My lord, we had indicated 2 sale deeds. My submission is the court has relied on those sale deeds to grant us a bare minimum average of this, not the entire amount. So in one of the sale deeds, the amount was 7.59 lakhs per kata. The other, my lord, was more than 6.5 lakhs per kata. Average would come to 7 lakhs. The final value which is given is 2.5 lakhs. So my lord, it is not that the court has taken those sale deeds to be sacrosanct. Those sale deeds, the figures mentioned therein is much lower. If, this is my submission, my lord, if today, because we have taken out a present market value from the Directorate of Registration and Stamp Revenue, Government of West Bengal for the same property. Presently. I understand that there is an indexation point which will, my lord, trouble us, but presently, my lord, the amount for this is 65 lakhs per kata.
That those valuations which are done only under Section 47 capital cannot be considered as a market value. And you are taken out and you are arguing an appeal.
Lordship.
The document which was not there.
It was not there. So order 41, note 27, I have not made an application. I understand that, my lord. That's the reason, my lord, I could not place this on record because, my lord, for that we have to take out an application for. So, my lord, the only reason I'm making this submission is because today.
Rely on that document.
Lordship.
Secondly, you cannot argue because the Supreme Court has held otherwise.
So today I am then, my lord, only to fall back on the findings given by the court, the trial court, my lord, only to this effect that today the figure which is arrived at is, my lord, after the submissions were noted, exhibits marked, cross-examination happened. I do not have, my lord, the benefit of those documents before me. My lord, today to make those submissions by falling back on those documents. We are taking the court records, we are taking the observation of the court in the judgment, which, my lord, takes into consideration the comparable sale deeds to arrive at this figure, which is, my lord, 7 lakhs on an average at that point in time, not today, my lord. Today it's much higher. I know I can't my lord, place reliance on. I do not have an application before your lordship under Order 41, Rule 27. It's not heard. So I can't. It's not my appeal also. Today I am restricting, my lord, my submissions to this. That today there were two comparable deeds which were considered by the court at that point in time. No, my lord, 250,000, my lord, even if it is disbursed. Yes, my lord, my instructions are these. So I'll be, my lord, I'll be restricting my submission with this. Even if this is given, yes, my lord. Yes, that's my instruction. If it is disbursed at the earliest, my lord, they will get the remedy they want, my lord. Indeed, my lord, that's only, my lord, my very humble submission. Because today, I also do not have a cross objection or cross appeal, my lord. The other respondents do have it. So, my lord, I have to restrict my submissions to this. Although maybe, my lord, since I was not there at that point in time, we should have filed a separate, my lord, but we can't. So today, my lord, I'm restricting my submission to this figure. And my lord, these are my very respectful submissions. There's no, my lord, point in my elaborating with other judgments because this is what covers my case, my lord. My very respectful submission.
My lord, my learned junior friend, my lord, although my senior in the rank, my lord, he has already submitted my before lordships. All the points regarding my lord belting method, regarding my lord the arm length, my lord, theory, whatever your lordship has taken, my lord, that I am consisting, and also, my lord, I am relying on that very point. Whatever the judgments we have placed, my lord.
Hearing concluded.
Yes.
Follow tomorrow, next week. Yes. Maybe like that. Okay. Yes.
তোমাকে দেওয়া হয়েছে
Deeply obliged, my lord.
দাও রিটেন নোটস আমার কাছে কোনো কপি নেই এই তোর মধ্যেই ঢোকালো ওর মধ্যেই ঢোকালো ওকে আরেকটা দরকার
আচ্ছা আমাদের নোটস ফাইল হয়ে গেছে মিলাদ তোমরা নোটস ফাইল করে দিয়েছো করে দিয়েছো
খালি অ্যাডপ্ট করে নাও
আমাদের তো নোটস আছে রেডি করা ফাইল করে দিই ভাই মানডে বাই টুমরো
selling in the same boat.
না সেটা ঠিক আছে শুড আই ফাইল আ সেপারেট নোটস
Yes. No.
But may we also put in a short notes by tomorrow, Milord? It's ready. Milord, if your lordships permit us by tomorrow, we'll, Milord, deeply obliged. It's deeply obliged.
Item number 6.
Nobody is coming forward. We are dismissing. So it's a very interesting point is involved. We are hearing it, B.Ed qualification. If they think not to come.
Item number 7.
I appear on behalf of the appellant.
the impugned order, so she will find. সেগুলো কোথায় জানি
Yes.
She was found as order impugned. Now, herein I have claimed for an arrears.
Nothing. Prepare a paper book only. Nothing here. Only the memo has been.
Only memo is there, but what I find a subsequent
Paper book.
now only another thing I will be beseeching before the court. There has been subsequent developments and there had been further release. Now, only thing what I'm on, kindly grant me a supplementary affidavit to this effect also.
Having filed way back in 1980 without accompanying any applications. The matter is simply running in the docket of the court. And we are never listed reporting for the court the date of its file. There is no representation on behalf of the respondent. The learned advocate for the appellant submits that there has been some certain development taken place in the interregnum between the filing of the instant appeal and this date, which are required to be brought by way of affidavit. Such leave is granted. Let the paper book, informal paper book, be prepared within 4 weeks from the appellant is directed to communicate this order in the office of the government pleader immediately.
This
Not supplementary affidavit. No application filed, supplementary affidavit. How can it be filed?
These are the subsequent.
Supplemental to what? Tell me. There must be an existence of something which is supplemental. Supplementary affidavit. That's why I say affidavit you file.
Affidavit, now, your lordship is asking me to file the informal paper book. Informal paper books will carry the documents which were already there, but subsequent documents.
See, affidavit.
Affidavit, grateful. Not supplementary, direct and affidavit. Grateful. Lordship is posting it after 4 weeks.
What you mentioned, you were just preparing. Yes, next.
Item number 8.
Supplementary. Okay.
Item number 8.
You appear correctly. Dismiss.
Item number 9.
9, my lord, I am appearing for the, my lord, appellant. My lord, which I beg to be excused at the outset. Mr. Kamalesh Bhattacharya was there in 2012, my lord, when this appeal was filed, my lord. So, my lord, I have to collect the papers, my lord, from the, my lord, department. My lord, kindly allow some time, my lord. We have challenged the impugn order. My lord, the papers were, my lord, with Mr. Kamalesh Bhattacharya. I do not find any paper now. And 2 weeks time be given, my lord.
No. This matter is pending since 2012.
Yes, my lord.
Not more than 12 years.
Other side is also not here, my lord. Kindly grant some
I
time,
think
my
the
lord.
respondent, has he attained superannuation? Might have. Everything is gone.
For that purpose, my lord, I have
For
to
that
take, I
purpose.
must take a instruction from the department and collect the papers,
Sorry.
my lord.
Keeping this matter on Thursday, if you can come, otherwise we are not going.
Thursday.
On the prayer of the learned advocate for the appellant, let this matter be listed on Thursday. On the prayer, let this matter be adjourned. Full stop. List the matter on Thursday.
Great.
Solve.
Item number 10.
10, my lord. I am for the, my lord, I have to ascertain, my lord, whether, my lord, I may appear in this matter.
There is all facial expressions, the body language shows
Well,
you
what-
wanted an accommodation.
My lord, what?
There is a confusion, to be
Adjournment.
honest and candid.
Yes.
My lord, because the brief was not with me, it was given to me 2 days back. On the other day, I submitted. I didn't notice it, my lord, that at all material point of time, Mr. Uday Shankar Chattopadhyay was appearing. His name is appearing. My lord, since the paper book, as I find, was served upon him, it was received by his clerk. Now, today, my lord, I found that Uday Shankar Chattopadhyay's name is there. Then, my lord, I met him. About 10 minutes back, I was.
Have you filed your Vakalatnama subsequent to that?
No, it's not. I am acting as a counsel. Mr. Raghunath Chakraborty is there. I am acting as a counsel.
Yes.
This is the position, my lord.
Argue. Argue the matter.
As my lord pleases. As my lord pleases. My lord, the order appealed against is at page 31.
The only point of law you have indicated is
as to whether the action of the respondent is arbitrary, whimsical or not.
Yes.
And as whether the action of respondents are tenable in eye of law or not. This is the only 2 points.
Yes, only thing your lordship will kindly see. The question is, my lord.
That is the question you have said, framed.
May I submit? The thing is, the question which was
The
posed
thing is
by my
that
lords, the other.
a drafting lawyer should be very careful when he drafts the petition.
It's true. It's true, my lord. I cannot join any issue or I cannot make any submission on that. But otherwise, my lord, your lordship will kindly see that the learned single judge was pleased to direct to award 5 marks. So the first and foremost thing would be what was
Just 1 minute.
Yes, yes.
Are you interested now?
My lord, I could not, my lord, matter has gone out.
Everything is still now. What do you want? Why you are challenging it?
No, I am challenging because your lordship kindly allow me, my lord, 3-4 minutes. The petitioner, my lord, writ petitioner rather, my lord exhausted all 3 chances.
দেখো তো certified copy of the impugned order আছে file এ?
Yes, yes, my lord, it was, my lord, it is in the paper book, my lord will find the
certified copy file করেছে original আছে তো চিঠিটা কপি করেছে ফাইল হয়েছে কবে আগে প্রথম
at page 78 I have disclosed, my lord, it was applied for
অর্ডারের ডেটটা কবে দেখি
certified copy was applied for on 22nd of July.
14
সেকশন 5 আছে 21 সেকশন 5 আছে
None.
ফাইল করেছে কবে last one. Now, sir, that's right. ঠিক আছে ঠিক আছে স্যার
লিফটের সামনে যান খবরটা দিয়ে না ওরা তো এখানে আড্ডা হয় ক্লাব পার্কগুলো ওই যে আমাদের সামনে যে লিফটটা এখানে যা পেটের মধ্যে দুটো মেয়ে থাকে পেপার বুক যে আমি রিসিভ করেছি না পেপার বুক যে রিসিভ করেছি
yes
Isa.
so where is the rule
I'm showing, my lord. The thing
just
is,
only small point sir the rule it says that the when you strike out the marks the rule says that you'll have to put your signature show us the rule
I'm showing, my lord. My lord, it's that the signature is to be there, my lord, not by the examiner himself.
please show us the rule
Your lordship kindly see the first page, I believe, my lord, will make the position clear. Eh? And this is the regulation I have given, my lord, so far as review is concerned.
Yes. Now, my lord, the fact that the petitioner has availed the opportunity of review has been suppressed in the
First thing is, he is a general candidate or honors?
No, he honors candidate.
He's an honors candidate.
Yes, honors candidate.
Because I find there are different parameters.
Yes,
first.
yes, man.
Yes, then,
He's an honors candidate.
yes. Yes,
Now, you'll also kindly take the trouble of looking into page 59, which was disclosed in the stay petition, my lord, because there was no opportunity before the learned single judge. That she has
has he paid that
At
2,000 rupees or something?
59, page 59.
Has he paid the requisite amount of charges
Yes,
for
yes,
review? Applied for a review or scrutiny?
No, she applied for review first. Review order remains unchanged. Thereby, her avenues were closed. Despite that, he made an application for post-publication scrutiny. Thereafter, my lord prayed for copy of the application and approached this honorable court. You will also kindly come to page 59.
Now, must tell me. Facts, let me ascertain the facts.
Yes.
First thing is, he or she, I do not know.
See, my lord.
He applied for review.
Yes.
There was no change in the marks.
Review. Yes.
Marks.
Yes.
Remained as it is.
Yes.
Then she applied for post-publication scrutiny.
Scrutiny, which is not available to her after scrutiny, after review.
In the scrutiny,
Yes.
it appears that 5 marks have been deducted.
No. 5 marks was deducted, my lord. Initially, the examiner who examined it, and my lord, then that post-publication scrutiny, as my lord is thinking of, is not that. But there is a moderator, and the head examiner. They, my lord, perused it. And my lord, those signatures are there on the first page, which has been marked up and copy has been supplied within a year. This is the position.
Who scored through?
But the examiner himself. The examiner himself, my lord. That's why some note of interrogations are there in the relevant page of the answer script. This is there, my lord. It is not the practice, my lord, as has been written by the controller of examination. And if my lord finds, my lord, her result, my lord, this is the third chance. Third chance, my lord will see, peruse the
What third chance?
third chance in part 1 examination. Your lords will kindly come to.
Passed or she has failed?
No, she has failed. In part 1, she has failed. She has not passed at
The
all.
subject.
Yes. Thereafter, my lord, since 3 chances have been exhausted, she is no more, my lord, allowed to continue. Your lords will kindly come to page 25.
Just ascertain the facts. She was failed in that particular last attempt.
No, in all 3 attempts.
All. She was also failed. Now,
Yes.
I have failed. Also, word I am using.
Yes.
She also failed in the last attempt.
Yes.
She wanted a review.
Yes.
Review does not bring any alteration.
Yes.
As it is.
Yes.
Then she applied for scrutiny.
Re-evaluation. The word used, re-evaluation.
Is there any provision for evaluation?
No.
Re-evaluation, no word.
No.
Then
after scrutiny, this is
it's
there.
a scrutiny.
Yes. No. After that, my lord, review, my lord, that cannot be re-evaluated. That is the.
Oh, that is there. I understand.
Yes.
Then you say she applied for scrutiny. There are 2 avenues open. I have seen, regulation.
Yes. Kindly.
One is with regard to review, another is with regard to scrutiny. And both the parameters are different. The scrutiny, what is supposed to be done is given.
Yes.
Which is not in case of a review. Different.
Right.
So that's why I'm asking, she applied for a scrutiny or what?
We applied for re-evaluation. You will also say.
Re-evaluation. But you have done a scrutiny.
No. The scrutiny, my lord, post-publication scrutiny was there. That was also there, my lord, pursuant to earlier order.
That's all.
Yes, my lord. You will also kindly see.
Anyhow, let us see.
Yes, ma'am.
You have another bench. We will hear you.
My lord, I am not in this matter most probably.
Then who is for?
My lord, Uday Shankar Chatterjee. But I am trying to
Call
inform
him to come at 2.
My lord, your lordship, kindly excuse me, but I have to leave the court for personal reason. For personal reason, my lord.
Not today. দিকে বসবে তো
অনলাইনে
What is the point? What is the point? Oh, acha, acha, acha. Yes. Yes. Mr. Mukherjee.
Yes, I'm present.
I know normally you will not, but this is such an issue. We think that your assistance is immensely required and valued. The point is absolutely civil in nature, I tell you. The point is, suppose an ex parte ad interim order of injunction is passed by a trial court. It is amenable to be challenged by way of an appeal under Order 43, Rule 1R, no difficulty. The appeal is filed. In the meantime, because it is for a shorter duration, it is extended. Now, whether a further appeal is required to be filed, because each extended order is an independent order. There are two views of the two division bench. So this is a larger bench constituted to answer that. That's a very small point.
I would beg to assist your lordship. Kindly fix it any date.
Any
after
date.
stability.
I will be inviting, just reminding you of my days with you. If you remember that the bench, division bench, where there was a split opinion of the division bench, it went to the third judge. Question of renewal and extension.
That's the relevant point, Lord.
Renewal of the renewal or extension. Their 1970 judgment, that is a Delhi Development Authority's case, was cited. Mr. Dasgupta was appearing for the other side. I had a privilege of assisting you.
I do not remember, my lord. Can you excuse me?
Ranjit Ranjit Kumar Datto versus Tapan Kumar Shah.
Yes. I now remember, my lord, is my, you are my client.
Yes. So there the question was renewal and extension. The difference. What is the meaning of the word renewal and what is the meaning of the word extension? Provost case. Provost case is also there of the Supreme Court on that.
I'll prepare myself and make my submission.
When we can keep it as per your convenience, no difficulty.
Will it be convenient, Lord, if it's fixed up after 17th?
No difficulty. Give me a date.
No, according to your lordship's according to your
After
lordship's
17, give me any date. Give us. No difficulty.
Because while the conditions appearing in the other in the matter.
Learned Advocate General is appearing for one, and other side, Mr. Aniruddha Chatterjee is also appearing. You are also appearing. Mr. Aniruddha Chatterjee is not appearing. No. Mr. Dipanjan Sinha is appearing.
18, 19, delegate. 18, 19, delegate, Lord.
18 or 19, tell us. Any day. It's a July. 19th is a Friday, sir. Can we fix it on 18, Thursday? Huh? What time? 2 p.m. will be convenient or morning?
Any time, Lord, according to your Lord.
No. Just tell us what is convenient, more convenient to you. Morning or afternoon?
In the morning, Lord.
In the morning. 10:30? Yes, morning, 10:30. Mr. Shakinath Mukherjee, the learned senior advocate, is requested to assist the court as amicus curiae, who is also present virtually. We were recording to him. The matter may be placed on 18th July 2022 to be taken up at 10:30. All the appearing counsels are directed to hand over the requisites document as required by Mr. Mukherjee in course of this week. I'm sorry, Milad.
That's all. I expect Mr. Advocate General also to guide me, Lord. He's there, my Lord. He has.
No, Mr. Mukherjee, they will go. Learned Advocate General will definitely give you all the papers. He will send you.
He was kind enough to ring me up.
If you want. I think the only thing is the orders which were passed. That's the only reference. Because the point is, Mr. Mukherjee knows it very well.
I'll go through it, my Lord.
I think from the core of the heart, he can argue.
Yes.
Spontaneously.
Spontaneous arguments with page numbers. And right-hand side column or left-hand side column?
Yes. Yes. Come on, 18.
18th at 10:30.
Please. Whatever he wants, just apply it. Yes, thank you, Mr. Mukherjee.
Take me, Lordship.
তিনটে নামাবে তিন কপি তো সব রেডি করা রেখে দাও ঠিকই আছে ঠিকই আছে মানে মিলন বর্তমানে তো এক নম্বরটা এক নম্বরই তো ওইটাই যাচ্ছে এবার পোস্টমর্টম করেনি ঠিক আছে ওটাই পোস্টমর্টম হয়নি পরে
আপনি ছিল থাকতে পারতেন তো, থাকলেন না কেন?
আমি তো নাও বলে দিয়ে গেলাম
কাকে বলে দিয়ে গেলেন?
আমি কোর্ট অফিসার
কোর্ট অফিসার জজ না, জজ ওপরে। আপনি ছট্ট চলে গেলেন, আমি তো বললাম যে আপনি মনে হচ্ছে এখানে থেকে দাঁড়িয়েছিলেন, আপনি বেরিয়ে গেলেন। আমরা বলে দিলাম যে হ্যাঁ উনি এসেছেন, আপনি তো দাঁড়াতে পারতেন, ডিসমিস করে দিয়েছে। হুম হুম। কম হয়েছে। অগস্ট মাসে 1 তারিখে এটা আমি দিয়ে দিচ্ছি জেরক্স করে। আমি তো আজকে জন্মদিন রেখে দিয়েছি, আমি এটাতে পুরো হেল্প করে দেবো, অ্যাসিস্ট করে দেবো আপনি। হ্যাঁ স্যার, তাহলে একটা সাথে সন্ধ্যেবেলা কথা
কটা থেকে সেটা?
25 হয়ে গেছে। হ্যাঁ, পাশেরটাই চাপ। এখানে বেঞ্চ আছে, একটা 25 হয়েছে, পাশেরটাই চলে গেছে। ওটা ভাঙা, ওটা
তাহলেই হয়ে গেল, চেঞ্জ করে নেন না। আচ্ছা না, আমি পছন্দ পাঠাটা পাঠানো মানে লাগে।
আমার এগুলো পোষায় না, সিম্পলি আমার এগুলো পোষায় না। আমি এর আগে অফিসে নিয়ে ঝামেলা হতো, এখন কেন আমি শুধু মেসেজ করছি সরি আর তোকে আমি সাথে আমার কথা হয়নি, এখন কালকে তো কথা হয়নি, পাড়া থেকে আমাকে টেক্সট করে
Item number
on behalf of appellant. My lord, last official, my lord, directed to serve notice upon the other side. I have to serve. But this is the notice. Well, here on in this case, the person are claiming as organized a teacher to be appointed in the institution. When there is no institution at all, my lord.
Where is the impugned order?
Yes, my lord, impugned order, my lord. At my lord.
101.
Oh no, 108. 108. The ex parte order, my lord.
আমরা বরং জানতাম হাইকোর্ট ফাইলটা
Where is the order of Justice Lala?
Justice Lala. My lord. It's 67 to 72. Start from 62. My lord, order start from page 70. 70. Question only decided by only new setup.
Where? Where is the order of the DI?
DI. On page 96 to 100.
Uh,
For non-implementation.
what is the date of her engagement?
Engagement. No engagement was given.
What?
No appointment.
Sorry?
She claiming.
She is claiming as an organizing teacher in the school since when?
My lord, no appointment is there. No, nothing.
What
But
appointment
she is claiming. My lord, kindly see first, my lord. Page 35 to 37. Page 35.
1993. What are you talking
1993
about?
is claiming.
The judgment. Yes. So you did not oppose that.
No, my lord. That
You
has
did
been
not
given,
oppose. You did not
my
appeal.
lord,
Nothing.
that has not, but that has been given by the managing committee. Well, when there is no recognition, well, first recognition kind of thing. Add up 35.
Page
35. Start from page 35. First recognition of proposed new setup for class.
Now, new setup you can't take. Justice Lala has said that this is misdemeanor.
But,
You can't use the
but
word
that has
new
not-
setup.
That has not been extended after only for 1 year.
That I understand.
Here, other observation is there. No student should be admitted. Number one. Number two, one that any engagement is to be happened of the teacher that should be through the school service commission. Start from page 36. This to grant provisional recognition of the school for a period of 1 year.
This is the first time you are bringing all those documents. You did not produce before the trial court.
Because of ex parte order.
Ex parte order. You were served. Why you did not appear? Ex parte order. What the court is supposed to do? Wait for you, give you invitation card.
Certainly not.
You were served with a copy of
My
the
lord,
application. Why you did not appear?
Earlier, my lord,
Earlier-
no one appeared, my lord.
Earlier, so
My lord, only I want to show my lord only one. First, by one of the trial judge. Page 1211.
what you have stated that why you did not appear?
That, my lord.
That why
My
not?
trial sheet page 211. The contempt proceeding was started before the trial judge. But trial judge said there is no existence of the school. Page 211 in the contempt proceeding. Drop, contempt petition drop. My lord, the report is there, my lord, which starts from page 193, 196. Start from page 193 to 196. Well, there is also judgment, honorable court. Even if the name of the petitioner in the reality report, the person cannot be regularized. Kindly consider. I have brought that judgment.
Go before the writ court. Do whatever you
As
want.
your lordship. As your lordship.
The order issuing a writ of mandamus directing the authority, directing the district inspector of school SC Purulia to regularize the service of the respondent is the subject matter of is assailed in the instant appeal. The respondent claimed to have been engaged as an organizing teacher
and rendering services since 1993. Comma. Her services could not be regularized despite the school being recognized subsequently.
Well, provisional and provisional.
What?
One.
Please.
My lord. Excuse me.
It's their case.
My lord, excuse
I am recording.
Yes, yes.
ঠিক আছে. Despite the service, there was no representation on behalf of the state, and therefore the single bench proceeded on the basis of the assertions made by the respondent. Full stop. Previously, a plea was taken by the state authorities that the school being a new setup, there is no question of regularizing the organizing teacher. The said decision was challenged before this court in WP number 10501 W of 2016, and by full stop 16 full stop. While disposing of the writ petition, it was observed that the expression new setup as used by the authority where is the judgment of Justice Lala? Which page?
Justice Lala, my lord. Page 67 to 72. Page 67. 272.
Is misdemeanor and cannot create an embargo upon the school from having the benefits available in accordance with the rules. The sum and substance of the said order clearly discernible therefrom is that the expression new setup as used by the authority was found to be misdemeanor and should not be used for the purpose of not granting the recognition to the school, semicolon, as a consequential effect in refusing to regularize the services of the organizing teacher. The appellant has produced several documents in the instant appeal, throwing light on the fact that the school where the respondent number one claimed to have been engaged as an organizing teacher and discharging the duties were given a provisional recognition for a period of 1 year, which was not extended subsequently. Even a report in terms of the order of the single judge, even the report does not suggest any existence of such school. All such documents
are produced for the first time before this court in an appeal, as the state were not represented when the writ petition came to be filed and disposed of. In our opinion, those documents are relevant for the purpose of determining the issue raised by the respondent, and an opportunity must be given to the state appellant to bring the same by way of an affidavit. Since the single bench did not have an opportunity to deal with those documents, we feel that the matter should be considered upon exchange of affidavits. Furthermore, the contempt application filed by the respondent faced dismissal on the score of non-existence of the school, which in our opinion is also to be taken into account after affording an opportunity to the state. Accordingly, the impugned order is set aside. The matter is remitted to the trial court for decision on merit. The appellant is directed to file affidavit in opposition within 2 weeks from date. Reply, if any, shall be filed by the respondent within a week thereafter. The writ petition shall be disposed of on merit. The appellant is directed to communicate this order to the advocate representing the respondent number 1 immediately. Despite the notice having served upon the advocate representing the respondent number 1, there is no appearance on her behalf. Let the communicating letter filed by the appellant be taken on record.
Well,
Why you are interrupting?
I'm grateful to Lords.
Difficulty is when we record the other side's stand, you people jump. Right. If you have a right to have your submission recorded, then they equally have a right to recording of their submission.
Right.
Why you people become so impatient?
My Lord. I'm grateful to Lords.
Don't do that. What the juniors will learn. Yes, call the next.
Item number 12.
I am appearing for the appellant, my lord. This is it. Disposal.
Yes, sir. Where is the other side?
My lord's direction. I have
Mr. Shaurav Mitro.
Yes, I have gone to serve them. My lord, the Shaurav Mitro has said that the advocate on record is Gautam Kumar Maiti. He has refused to accept the notice. He said that he will not accept them.
Why?
Because probably he has no connection with the.
But his Vakalatnama is still there.
Yes, I have, my lord, we have gone to serve him. My lord, he has not.
Where he sits?
My lord, room number 2.
Go and tell that the bench wanted him to be here. Can you send your junior? Just tell that the bench is waiting for him. Wanted. Yes, what's the next?
Item number 13.
Your Lordship, on behalf of Dr. Sutunu Kumar Patra, appearing for the appellant, my lord, I am saying not today, my lord. He is engaged in a continuing part-heard matter before the Honorable Division Bench.
This matter was fixed today.
fixed at 2 p.m. my lord today.
There is
Upper
one,
primary
there is
matter.
another advocate. He is not appearing alone. Who is assisting him?
Engage before courtroom number 18, my lord. Matters are going on, my lord.
Dr. Patro may be there. Who is assisting him?
Miss Supriya Dubey, she is engaged before courtroom number 18, my lord.
Call her.
I am praying only
If you
now.
have no authority, we will not recognize you. You are not in the matter.
I am
Sorry.
praying only not today, my lord.
No. What is your authority? The advocate and record has instructed you. No.
I am instructed by Dr. Patro, my lord.
Maybe he is instructed by the advocate and record. He does not have an independent right as a
And I
senior
am praying
counsel.
Miss Dubey, my lord. Right.
What? 14. Same.
Yes, none appears. Dismiss. Next.
14 dismiss. Alright. Item number 23.
23. Yes. Lord,
14.
Mr. Bari appeared on the other day. My lord, 23. Before taking up 23, if your lordship may kindly takes up 38, because these are two analogous matters. And in 23, my lord, only the memo has been filed. There is no application. And my lord, there has been a terrible mistake for which, my lord, Mr. Bari got annoyed in this morning, because the private respondent had not been served, and it was noticed by us, my lord, yesterday.
What are you doing, sir? Have you seen the report of the stamp reporter?
My lord, 23, we are not there, my lord. That is the problem.
We are not there, then who are you? Why you are coming?
My lord, 23, since 23, my lord, Mr. Bari has been engaged as a senior in both these matters. In 38, my lord,
He is the advocate and record in 23.
my lord, 23 AOR is, my lord, I do not have any personal.
Let it be dismissed, and then AOR will face.
Your lordship may kindly takes up 38, because Mr. Bari had, my lord, submitted. Well, if 38 is heard, my lord, along with this.
No, there are defects, sir. There are many parties who are not made a party here. Who is the advocate and record? Sayyaz Niaz Ahmed. Where is he?
My lord, we are not acquainted with him, my lord. My lord, he has not, my lord, engaged us, my lord. Since Mr. Bari is
dismissed.
My lord, may I submit, my lord?
Who are you?
My lord, I am assisting counsel, my lord, in this matter, my lord.
Who's the assisting counsel? Appellant or respondent?
My lord, appellant, my lord.
Then there are defects.
My lord, all defects has been cured, my lord, and Mr. Imtiaz Ali has been taken NOC, my lord, and he has filed the NOC, my lord. He is junior of Learned Senior Counsel, Mr. Bari, my lord.
Several defects which have been pointed out. Nothing has been done.
My lord, all defects have been cured, my lord.
Where? There is nothing which I could find from the record. Simply sitting in a air conditioned atmosphere will not do.
My lord,
nothing has been done.
My lord, then kindly grant me one big time to do needful, my lord.
The defect pointed out by the stamp reporter, if not removed within 2 days from date, the appeal shall stand dismissed. It's called
one week, my lord. My lord, one week, my lord. My lord, 1 week. Be granted, my lord.
2 days.
24.
24, my lord. I am for the appellant petitioner.
But this matter relates to the recognition of a junior high school at in Noida district, Milord. But last occasion, a lawsuit asked me to provide some old documents that the school was set up in the year 1985. And now, my lord, this is the old document actually I got. Yes. The school was renovated. Yes. Yes. The school was set up in the year 1985, my lord. Thereafter, my lord, so many, my lord, order has been passed before the Honorable High Court, Calcutta, my lord. And last occasion, my lord.
Show us the document that it was established in
These
1985.
are old documents, my lord. Actually, this school was set up in the year 1985. Thereafter, my lord, in 2000, there was a flood, my lord. Some important documents have been lost, and now these are teachers attendant registers. It was since 2000 actually.
How it was? Where is the recognition?
No, I am praying for recognition, your lordship. I am praying for recognition, my lord, since 2011. 2011, the matter was
Secretary of the Managing Director.
And this is the attendant register, my lord, 2000. Yes.
2000, how it will do? 1985.
Yes.
Nothing. Where is the old document? One letter will not do.
Old document,
this letter.
No, my lord. This actually, this is a register, attendance register
of 2000 report.
Yes, 2000.
Where is the 1985 document?
Yes, that document has been lost, my lord, due to, my lord, flood. Flood has rushed away the entire documents. Yes. So these, my lord, these documents should be verified by the district inspector of school, district level inspection team. But just, my lord, whispering, campaigning, canvassing from the local, they collected the news and submitted a report, my lord. They should go and inquire properly, my lord. That is why I made representation. That has not been done.
Not a documents are coming forward. No documents have been produced by you regarding.
No, my lord, these documents they didn't show it. So after showing documents, they will submit a report. They will submit a report.
Yes. Look at you are a very responsible member of the bar. Do you think this document is of 1985?
This is 1986.
Correct.
86.
Do you think?
86.
Do you think?
So far the date is concerned, my lord,
I am talking about the document. Look at the document. Apply your conscious mind. Tell me, can anybody believe that this document relates to 1986?
Here, lots of justice. Director of district inspector of school
to go and make an inspection. Inspection report says no existence.
There is no.
He has produced the document. Yes. I'm just giving him the document.
এই স্কুলটা দিয়েছে 1986 এবং ওটা বইটাও দিয়েছে এইগুলো তো ভেরিফাই করে দেখে তার রিপোর্ট দেবে
স্কুল রয়েছে মানে স্কুল is there but they are saying school is not there. 1985. Their grievance is there is no school, but the school is there. No, my lord, the temporary structure was there. Now it was renovated into recently. Earlier order says school is there. My lord, kindly see my lord page in my appeal. My lord, kindly have a look. My lord, page 67.
67, my lord, 60, 66, 66, that temporary structure is there, and they have already, my lord.
What 66? Temporary structure?
Yes, that is at building temporary structure. 66. At the bottom, my lord. 8. There's earlier DLIT report, my lord.
No, that is 2014.
Yes,
so
earlier.
Who says 1985?
The school was set up in 1985.
So we wanted to know that.
Thereafter, my lord. My lord, kindly go through page 70, my lord. General observation of the district level inspection team in respect of Kalinagar Junior High School. Basically, it is a coaching center, my lord, what they are saying. Basically, it is a coaching center run with the student of nearest high schools. At the time of inspection, it has come to know from the students as per attendance register, summer vacation has been started with effect from 2nd May 2014, but students are called for inspection on 21st May 2014, and that is the date of inspection. Teachers are not paid remuneration, but acquittance roll is found, but not signed by the employers. So, my lord, this is the observation, this is the report in 2014. And now in 2023, they are saying there is no school.
Where is that 2023?
Kindly see, my lord, page. Page, my lord, page 56. Page 56. After the order of Justice Saraf. My lord.
Just 1 minute.
My lord, page 56, just at the bottom, my lord, just above just one paragraph above, my lord, the local inhabitants of the said locality also.
Sir, are you a Kalinagar Junior High School? Are you a Kalinagar Junior High School?
Yes, my lord, Kalinagar
Junior High School.
Yes.
There is an existence of a Kalinagar Babsai Primary School. I do not know. What is this? Vaishyo. What is this? It's a key. No. What is this? Bill Vaishyo.
Bill Vaishyo.
So you are not a Bill Vaishyo primary.
No, I am Kalinagar Junior High School.
Correct. It says there is nothing. There is a dilapidated structure. Nothing has been found.
The local inhabitants, mother. Kindly see me.
No. Even a school's cook says never found anybody there.
So that is why, my lord, I kindly appoint a special officer from the court, my lord. Then, my lord, everything will be visualized, my lord.
Nothing.
Everything will be visualized, my lord, whether school is there or not. The teachers are coming, the students are coming. My lord, well, kindly
interfering against. You will never go against the Vaishyo.
No, my lord. My lord, kindly appoint a special officer. I shall provide the cost, my lord. No problem, my lord. Kindly, then everything will picture will clear.
Why the court should be used as a machinery to collect evidence for you?
My district inspector is not fair, my lord. That is why I have come here.
Your document.
No, my lord.
You have not said anything. Otherwise, we will send it to a forensic laboratory. You do not know.
My lord.
Send it to a forensic laboratory, this document. You are saying then at your cost we are taking it. So easy.
My lord, kindly, my lord, appreciate one thing, my lord, that this school is, my lord, running since 1985. I am not, my lord, saying that, my lord, one thing is this, my lord, due to, my lord, flood.
You have produced all those documents before the trial.
Yes, my lord, that has been shown, my lord. That has been, that is shown, my lord, but the trial court did not consider.
Appellant approached the rich court.
Thickly populated man is ST area, madam, scheduled tribe area.
Of the Kalinagar Junior High School as the sixth school is functional since 1985. Prior to the aforesaid litigation, in an earlier round, the direction was passed upon the concerned authority to verify on the existence of the said school. The reason for such direction is evident that the state took a view that there is no such school in existence. The report of 2014 annexed to this application does not appear to have supported such claim. Yet, in a subsequent round of litigation, the direction was passed to make a further inquiry. Stop. The report of the authority would reveal that there is no school by the name of Kalinagar Junior High School, but there is an existence of Kalinagar Bill Boisho Primary School, PO Shivnibar or Shivnibar.
Post Shivnibas, PS Haskali, District Nodia.
PS Shivnibar, PO Shivnibar, District Nodia. It is further disclosed in the said report that no teacher or student was found at the time of inspection during the working hour. The inquiry was made from the teacher in charge of the nearby school, who also communicated that there is no existence of any school by the name of Kalinagar Junior High School. The aforesaid facts is further corroborated by a cook cum helper of the adjacent primary school, as well as the inhabitants of the locality. The writ petition filed by the appellant was rejected only on the ground that there is no existence of a school, and therefore the prayer for recognition does not arise. Today, the counsel for the appellant brings several documents to substantiate that the school was in fact running since 1985. The attendance register, which is also produced, does not indicate that the said school is running since 1985. Nor it is still any confidence in us that the finding of the trial court on the existence of the said school can be faulted with. We do not find any
illegality and or ambiguity in the report of the authorities. Nor we could find any documents in support of the contention that the school was established in 1985 and is still in existence. The improved order warrants no interference.
But this school is especially my lord, thickly populated ST area, my lord. That is why the downtrodden people, they should may make some inspection, my lord. Downtrodden people, my lord, they're really, my lord.
For only a coaching center. Second time says
3 times inspection. Thickly populated area, my lord, kindly give us one protection, my lord. Just
at some point of time, there should be some kind of a
one protection, my lord. Why they will go, my lord? Actually,
it's the
false element.
Was done.
No, kindly.
So many times. Every time when you approach
I tender my apology, my lord. Kindly, my lord. Kindly give me one protection, my lord. Kindly give me one protection, my lord.
Sorry, no protection.
25.
Nothing. A lawyer. No.
But actually, my lord, the people, the poor will be more poorer.
So,
The rich will be more richer. That is why I have come before the lordship for the sake of justice, my lord. But no, my lord, they're downtrodden people, my lord. They're not enough money.
Come in another symposium. I will be there, happy to interact with you.
Yeah.
Any aspects. I will interact. Invite Mr. Bose, Mr. Sahara, everybody. Come. Another symposium. Wonderful. We will talk about this. Poor, downtrodden, unprivileged. We'll talk about it. What are required to be done, we'll talk about it.
One another inspection can be done, because
How many times? No. No.
But I am appearing for. This was heard by his lordship on the last occasion. Yes, man. I'm sorry. I'm sorry. I'm sorry. Yes.
Yes.
The documents in support of my husband's service has been drowned in rain, my lord, and the flood. It has gone out in rain and flood. 78 flood.
Where you live?
I stay in Murshidabad.
Which place?
78 flood. It has been taken away.
Whether Murshidabad, which area? There were certain areas we were affected, not the whole of the Murshidabad. Which area?
Bardwan. Bardwan Bridge. Bardwan.
What river goes by the side of your
Jolongi. No. Bhagirathi.
78.
78 floods.
Where it was not.
Pardon?
Not the entire Murshidabad was not under flood.
My client's house has gone there.
Only solitary house gutted in the flood.
The 78 flood was a devastating flood. I was there in Birbhum at that point of time. I have seen the train lines are submerged in water. Even the trees are, my lord, the leaf of the top of the trees only being seen.
When a skylab was going to fall, was there.
It is devastating. Someone who has suffered, my lord. But at the end of the day, my lord, I tell you, lordship, my husband was.
The document we will go. The court goes by the record.
I'm telling you, lordship.
Not go by
No sympathy. No sympathy. I am not asking for the sympathy, my lord. I am only saying, your lordship, the ground level difficulty the petitioner is facing. She is not getting any life pension, family pension, as due to the death of the husband. Now, my lord, kindly come to the first order passed by the Honorable Justice Somapti Chatterjee, page 52 in the writ petition. Page 52. Page 56, sorry, my lord. It starts from 52, operative part 56.
So you were permitted to rely upon the documents. Did you rely upon the documents?
Finally, I'm relying on the document, Mala, pursuant to the order passed by the Honorable Justice Chatterjee. Mala, that DI has, my lord, DI has issued an order, page 61. Page 60. That I am telling you, Lord, the school's document, school has admitted that she was working. Page 61, kindly come for once. Paragraph 2. Headmaster of the school submitted that he did not receive any copy of the noted writ petition. He also submitted that he know nothing about the claim of the petitioner, but he confessed that he issued a letter on 6 February 2007 from the said form of certificate that late Dijendra Ghosh served the school. Served the institution from 6/8/64 to 21st September 1968.
It should have been, because Lordship kindly seen page
He's avoiding,
69.
my lord. I have made him party. I have served him
Page
copy.
69, my lord. Page 69, my lord, it has been mentioned, my lord, by the DI. That I don't know, my lord. In
You asked that he is a weak, soft-hearted man
and
wanted to help somebody and he has issued.
And page 69, may kindly see, it is needless to mention that the headmaster of the concerned school is requested to. Yes, that's why I understand.
Page 63 also in document, my lord. DI's letter, school's letter, rather I should say. Headmaster is writing to the DI. Resolution number has been given, second paragraph, page 63. As per resolution so and so 64, late Dijo was joined the institution as on 6th of August 1964, and he was discharged from the institution on 1967 from the school by resolution of 67, and all copies of the MC resolution of the school is enclosed herewith, sent to DI of schools. What is the answer of DI to that?
So this letter was never sent to the DI.
Yes, because DI's my lord, order dated, my lord, that first order has been referred, my lord, last paragraph, considering the facts and circumstances, submission of the parties. School authority is directed to submit the so and so with supportive documents as per existing government rules. And the last page 69, Lordship has seen, my lord, they says, my lord, DI that while sending anything, my lord, that this headmaster should have been concerned school requested to remain more responsible while submitting the papers before the higher authority, and also to make responsible statement in future. This headmaster, my lord, once said
suspension.
that
now they say I was under suspension, therefore I was an employee. Suspension is not a punishment. If ultimately I die, my lord, with the suspension.
Lord, page 67, this headmaster sought for documents from the petitioner.
He is saying
And
that
he's saying that document has
Firstly,
been
he
submitted.
said that by resolution you are appointed. Secondly, he said that I was under suspension.
Everything destroyed in the flood. You got a good one, right?
This flood story, my lord, in nowhere in these documents.
Child of Mr. Bhattacharya.
Yes, I cannot say anything, my lord.
Not brainchild.
No kidding, but Mr. Brainchild.
Yes.
But fact remains, my lord, this widow of 1968 onwards is not getting pension.
We have all sympathy.
My lord, let the school come and let the school not avoid the court. Let the school come before your lordship. No stage of the proceeding, my lord, they are coming, but they are giving letter. You have suspended me, you have appointed me, you have a resolution for that.
School authorities, they appeared before the DI and they could not produce any documents.
Yes.
DI has given strict
But for that, my lord, I should not be penalized for that. My husband should not be penalized for that.
We are here ready to keep, provided you produce one document. Just to show your husband was working.
Let that direction upon the school be there. I shall be, the next day, let the school appear. And if your lordship passes that order, my lord,
The copy, what more?
they are not appearing. That's why your lordship, their presence is required. But their presence, their own documents show that I was appointed. The resolution,
The document.
they are saying that I forwarded to DI.
Any document before the
DI is suppressing that. They have
No,
said that.
what suppression?
Where is your letter that you have not received the
Page
document?
66, my lord, kindly see. Yes, saying suppression. Page 66, my lord.
No, you have been saying the records.
The letter issued by the school to the concerned my lord, petition appellant, my lord. Kindly see. Page 66, page 67 is the legible copy. In this connection, we beseech your kind cooperation by way of furnishing us with the following documents.
Resolution was sent to you. Page 49, the school
49
certificate.
and all.
School,
Kindly see, my lord.
school certificate, kindly look at page 49, school certificate.
The school authority doesn't possess a single document. For that period, they have asked us this document.
Is enclosed here with. Have you ever said that nothing has been received by me?
That is
2015 letter. 2015 letter you have not denied. The school's letter you received it. You have not denied. Page 63. Page 49, the school certificate that I was engaged there. I was working there.
Deadwood is sought to be resurrected by approaching the court at a belated stage. On the ground of sympathy, sentiments, and the empathy to be shown by the court in relation to an entitlement to family pension. The appellant claimed that her husband worked as assistant teacher between 1974
No, 1964.
to 1968.
Page 49, my lord.
I will indicate about that. Between 1964 to 1968, and unfortunately died on 9th May 1969. There was a complete silence for several decades after the death of the sick teacher. It is only in the year 2015 or so the process was activated for family pension. The authorities were the claim was founded upon a letter issued by the headmaster of the school to the effect that the sick teacher worked during such period, which according to the petitioner is a conclusive evidence of proving the fact that her husband was in fact discharged duties as teacher in the said school. Obviously, the moment a competent authority has issued a letter, the direction was passed upon the DI of school to take a stock of the thing and even
a writ petition filed earlier was disposed of directing the said DI of school to give a personal opportunity of hearing to the appellant. And also, liberty was granted to submit all the documents which can throw light on such and such. Our attention is drawn to the decision of the DI, where the decision of the DI taken after giving an opportunity of hearing to the appellant as well as the headmaster. The specific query was raised to the headmaster whether the declaration of the husband being the teacher between the aforesaid period is supported by any document maintained by the school. The answer was negative. No document was produced either from the appellant nor from the school authorities in support of the same. Even the DI has issued a letter of caution to the headmaster not to indulge himself in issuing such letter in reckless manner, nor should write something unsupported by a valid document, share on sympathetic ground. The husband died in the year 1969, and thereafter nothing appears to have been done at the behest of the appellant. Until a decade before, when suddenly the appellant woke up from the slumber and asserted the right based upon the letter issued by the headmaster out of sheer sympathy. Though it is sought to be contended by Mr. Borgias, the learned advocate appearing for the appellant, that all the documents that were destroyed in the flood of 1978, but we do not find any remnants in the pleading submitted before the trial court, nor before us. Since the petitioner have miserably failed to produce any document in support of a claim that her husband was working as a teacher between 1964 to 69, we do not find any infirmity and or illegality in the trial court. Appeal stands merit. The same is hereby dismissed. Yes.
26.
Oh. As regards item number 12, I have intimated that he has come. Can it be taken up on the Wednesday? On Wednesday. On Wednesday.
26.
For 26, I am for the writ petition I responded. And for the appellant led by Dr. Patra, Your Lordship.
The Patra has already concluded his submission. Your Lordship, allow me to make my submission just according to my way. Some deep facts is required to be placed before Your Lordship.
With certain hurdles and obstacles which will come from the bench.
Just give, no, I'm not saying so. Some facts is required to be placed before.
Own way, that's why I say subject to an obstacles and hurdles put by the bench.
I shall give reply, try to give reply all the obstacles, my lord.
Lordship, as Dr. Patra is engaged in a hearing, my lord, if any reply is required, Lordship, an adjournment may be given, my
Because
lord.
I had a talk with Mr. Patra, he told me that my junior will take note of your submission, and if necessary, I shall give reply in there. I shall not take much more time, my lord. If you also kindly turn up to page 62 of my writ petition. Well, stay application. Now, this is the notification issued by the governor fixing the number of seats, rather posts, in all over West Bengal. You will also kindly see page 62. This is dated, my lord. Kindly note the date, 28th of November 2011, in the top Gazette notification. Now, your lordship, kindly turn the page.
December, not November.
December, my lord. 28th December 2011, my lord. November. Lord, kindly turn the page at page 63. After the box B, the governor is further pleased to hereby to declare that all such posts are to be filled up as per qualifications and procedure as laid down the relevant recruitment rules as amended from time to time. This is 2007 rules. Now, your lordship, the numbers of vacancies has been given. If your lordship kindly turn page, my lord, 64. We are concerned about the Malda district that will appear from page 63, my lord, top, page 63 top, serial number 11. So for the secondary is concerned, 3107. Have your lordship got, my lord, top table number, page 63, Malda. Now, your lordship, kindly turn to page 65. The last paragraph I am reading starts, see, the governor is also pleased to hereby to under that the Director of School Education West Bengal, the Chairman District Primary School Council of concerned districts, the District Inspector of School, SC and Primary Education, and the West Bengal Service Commission shall take immediate step to fill up the newly created vacancies, that is a number of so-and-so posts for upper primary school and a number of so-and-so posts for the primary schools, following the existing recruitment rules, namely the West Bengal School Service Commission selection of persons of appointment to the post of teachers rule 2007. But now, your lordship, kindly turn the page. By the order of the governor. Now, page 66, I applied for and the interview letter has been issued. Rather, the written test call letter, page 66. This is the call letter issued in my favor after fulfilling the minimum eligibility criteria that has been issued by the School Service Commission.
Provisional admit card.
Yes. Admit card. For participating in the written test. I participated. I have been selected. Kindly turn the page, page 67. It has been downloaded from the official website of the Central School Service Commission. Kindly see status qualified. Roll number, everything is there. I have qualified. Then I wrote a letter at page 68 that I have 68. Since I have not been called for. According to the rules, after qualifying in the written test, interview letter should be issued to all the candidates. I have not been called for. So I wrote a letter.
Category OBCB.
Yes, my lord. OBCB. But then, your lordship, no answer. Kindly turn the page, page 69. আমি আমার উত্তরপত্র দেখতে চাই, আমার প্রাপ্ত নম্বর জানতে চাই, কত নম্বরে পাস করানো হয়েছে জানতে চাই. These are my queries. Kindly come to next page. They have intimated me that they have taken a resolution. Page 69. Next page. Addressing to my client, kindly see query result of the candidate of 12 divisional level cells. In the West Bengal Central School Service Commission 451 meeting dated 4th July 2013, following were resolved resolve that no part intermediate information in regard to the 12th RLST HM and 12th RLST so and so library and be provided to the information seekers under RT Act until finalization of the merit list. Some significance is there, my lord. Then, my lord, next page, I again wrote a letter under the RTI Act, page 70, same queries.
Why you will? Right? Because they say until the finalization of the merit list, then why RTI again?
After completion, I made a further representation and that has been answered. Kindly turn, my lord, page 70. My RTI, then the reply at page, my lord, 71. Assistant Secretary addressed to the Secretary of the West Bengal Central School Service Commission saying, I am directed by the Commission to request you to send information as regards the lot number so and so, key code so and so of Ujjwal Mandal, petitioner of your lordship, being roll number so and so. This is urgent required to show the concerned answer scripts to the applicant under RTI Act, pair of the candidate's Xerox copy. Now kindly turn the page, my lord. I have been intimated.
I have a request to all the members of the bar. This is not the way that you will work on a particular document. And
No, this is filed by the, this is not my appeal. This is not my appeal, man. I have annexed a better document in my writ petition.
All in circuit and all, everything, this is not accepted. You comment on this.
Well, this is in the appeal. They have used this in. This is not my appeal.
What is this going on?
This is not my appeal.
It's not a way to work on the document.
This was the writ petition, my lord.
It was, that's why I thought that it is really a
Yes, sir.
repletion of the writ.
It is with me.
You have submitted
No, I have submitted before the court a fair document. They have worked out it at the before the writ court. Now they have annexed those documents. It's not my fault.
It was a changed brief at the appeal stage, my lord.
That is their copy. They could have collected it from the office. Press copy could have.
That whatever misdeeds have been done by the earlier, you are not responsible.
And this is their document. They could have.
One care, but such and gone out.
Now, Bala, 2 lowest marks obtained by the candidate called for personality test 55, 56. I got 55 according to them, and the lowest person, the person who got the lowest marks to get the call for interview, got 56 marks. This is according to them. Now I deposited the money as per their instruction, page 73, rupees 40 as per direction, and this sheet has been handed over to me at page 74. But kindly see the left hand side top. এটি একটি প্রশ্ন সহ উত্তর পত্রিকা. Kindly take note of. Left hand side top, বেঙ্গলি নির্দেশাবলী. এটি একটি প্রশ্ন সহ উত্তর পুস্তিকা. প্রতিটি প্রশ্নের শেষে নম্বর নির্ধারিত হয়েছে প্রত্যেক শতাংশ। সিগনেচার পরীক্ষকের দস্তখত, সমীক্ষকের দস্তখত. Signature of the evaluator and signature of the scrutinizer. Kindly see, my lord, I got 43 initially. Top, bottom. But 43 plus 16 comes to 59. Last candidate got 56 admittedly. Now what they have done, by erasing 43, they have given me 39. And my marks reduced to 55. 1 mark short. But I came before this honorable court and filed a writ petition. My writ petition kindly turn to page 84. The first writ petition. Page 112, my lord. Sorry, page 112. My lord, 2009, a resolution, alleged resolution has been adopted by them. Never it has been published, never notified, rules have been not incorporated. The moment I moved the writ petition, before the court, they produced a resolution. Kindly see, my lord. On the pair of Mr. So-and-so, learned advocate of petitioner, the writ petition stand dismissed as withdrawn. Second paragraph. However, this order shall not preclude the petitioner to file a fresh writ petition on the self-same cause of action and to challenge the resolution of the West Bengal Central School Service Commission dated 31st December 2009 under agenda item number 10. But there is some significance, some indication. On the day of moving the writ petition, the learned advocate representing the council placed before the court this resolution. It has never been notified. It has never been incorporated in the rules. It is not even a government geo. Now, your lordship, kindly see, after this, kindly come to my lord the rules. Rules to motivated. But I have one book, if your lordship kindly allow me. I have another book. There are two flaps, white. First, your lordship, kindly see the act. Now, this is the act, West Bengal School Service. Kindly see West Bengal School Service Commission Act, the first flap. Kindly see the definition clause 2. Have a look at my kindly turn the page 2J, notification. 2J. Notification means a notification published in the official gazette. Then you will also kindly turn to section 17. Power to make rules. The state government may, by notification, make rules for carrying out the purpose of this act. Then, my lord, 17D. The manner and scope of selection of persons for appointment to the post of teachers under so and so. So, my lord, in respect of appointment of teachers, state government is empowered to frame. D. I am reading D. D. 17D.
Yes.
For appointment of teachers, rules can be framed by the state government in exercise of the power under section, my lord, West Bengal School Service Commission Act. The rule making power has been given in respect of appointment of teaching and non-teaching teachers. Now, kindly come to my lord, the second flap, the rules. White, second flap, white flap, my lord. No, this is subsequent to her. But that page, my lord. But this is West Bengal School Service Commission selection of persons for appointment to the post of teachers rule 2007. It has been notified on 26th of September 2007. You also kindly turn to Rule 7 first. Kindly come to Rule 5. Additional essential qualification of candidate. Rule 12 Rule 12 kindly come to serial number Rule 7. Manner of selection of teacher. Then kindly, my lord, come to Rule 9. Advertisement. The Central Commission shall, on receipt of the report of vacancies under Rule 8, issue an advertisement through newspaper in the state in English so and so. 2. Such advertisement shall be issued specifying the vacancies, qualification, age as on the first day of January of the year advertisement, and other necessary information. My lord, kindly take note of. Relating to such post, details of which may be obtained so and so. So, my lord, that should be in the form of a notification. Now, your lordship, kindly come to Rule 12. Selection of candidate and preparation of panel for the post of assistant teacher. My learned friend has relied upon Sub-Rule 5. Your lordship, kindly turn to Sub-Rule 5. The Central Commission shall decide the procedure and manner of conducting the regional level selection test by the respective regional commissions and shall issue detailed instructions in this regard in accordance with the provisions of the Act and the rules made thereunder. I'm pausing for a moment. My learned friend's case is that exercising this power, they took the regulation. Kindly read the next two lines. Provided that the Central Commission shall hold a meeting with the chairpersons of the regional commission before the instructions are issued. This is my case. Even if I are accepting, they have the power to take regulation, fixing some terms and condition. This has not been happened. There was no meeting, there was no deliberation with the district commissions. Admittedly, it will appear from the alleged legislation. There must be a deliberation, there must be a meeting amongst all the district committees. It says, again I am reading.
No, I got it.
Provided. So even if I accept the position that they can, beyond the rule, take some steps by way of taking regulation, but before that they have to conduct meeting.
Without a case like that,
My lord,
without a case of this nature,
my case is that you don't have any power. You cannot, unless it is incorporated in the act. By way of regulation, you cannot do it. Your resolution is bad. Accordingly, I have challenged the same. That has been quashed by the learned single judge. My case, specific case, I have made out my second writ petition as per leave granted by the learned single judge.
I understand.
I have specific.
No case that this particular mechanism or the manner of conducting the examination can only be done by virtue of the provisions contained in the rules, and there must be a prescription in this regard, which must be notified. Notification has been defined in the act itself, which says that it has to be published in the official gazette.
I am entitled to get a call. Subsequent thereto, they utilize this regulation. This regulation has never been published in any notification, not even a government order. It has not been incorporated in the rules, not in the act. 2000, kindly see the date of regulation, March prior to. Now, your lordship also can see, my lord, clause 7. After preparation of the list of qualified candidates, each regional commission shall call the candidates for personality test through registered post. So, at the moment I have been selected, my name has been published. There is no further scope for any scrutiny, any review, anything. I am entitled to get a call. I have qualified. Then, your lordship, kindly take up the so-called regulation. I can say this is nothing but a minutes of the meeting. Your lordship, kindly turn to page 58. What is this? Can they use this? This is a minutes of the meeting, not a government order, never placed before any authority. Kindly see present. Ranjit Basu, Chairman, Bholanath Banerjee, Member, Dr. Sanjukta Dasgupta, Member, Dr. Subir Ranjan Bhattacharya, Member, Badrul Islam, Member of the Central School Service Commission. So, to confirm the proceedings, resolve the meeting dated so-and-so, West Bengal, so-and-so. Then your lordship, kindly turn to page, my lord, 60. 10A, first line. The review on the process of examination conducted by the West Bengal Central School Service Commission due to the increasing completely and demands of the candidate in the background of attention. So, pausing for a moment. The intention is to provide the chance to the students, to the candidates for review. That has not been done in the subsequent paragraphs. Why I am saying so? They have relied on the dismissal judgment, where they have lost the case before the learned single judge. They preferred an appeal. The grounds have been taken under the 2007 rules. There is no provision for review. Division bench accepted their views. Have placed before your lordship on the last occasion, Justice Dipankar Datto. Now, your lordship, kindly see. This first paragraph says for the beneficiary of the candidates for review, but that has not been done in the subsequent paragraphs. Kindly read, my lord. With reference to the practice of the Public Service Commission, Railway Recruitment Board, etc., regarding review of answer scripts and also the view upheld by the division bench. Division bench, what says? You cannot do it. Rule does not permit you for any review or scrutiny. That's the division bench observation of the Honorable so-and-so, Sirpurkar so-and-so, the Samuelson so-and-so, judgment so-and-so. The answer script of the candidate be examined by the examiner as per model answer provided to him. Supervision over a set of examination is decided by the representative regional commission during evaluation of the answer script as conducted by the coordinating bench, so and so by the coordinating bench. Then, my lord, kindly say, third, checking of marks of each answer and its posting, which has been fallen from your lordship also. The marks you have given in various pages, whether the same marks have been posted in the top sheet or not, that's only, even if I admit, there is no question of re-examine on the answer sheet, because answer also provided to the examiners. Question answer both. Either I will get 2 or I shall get 0. 1.05 cannot be. 4 marks, 5 marks have been deducted from me. 1 mark is required. It does not say you can touch the mark given by the examiner. It says every marks has originally properly placed in the top sheet or not. Either it is, then the last line, your lordship, can say checking the marks of each answer and its posting in the top sheet done by the scrutinized, and he should be authorized to make correction for overmarking, undermarking. So if I get my lord 2, 2, 2, 3, 6, and mark sheet says, top sheet says if I got 5 or I got 7, it can be corrected. This power has been given. Although my specific case, this resolution has no statutory force. It has never been notified. 2019, you have not used it. Only after examination. Rule of game has been changed. It has not been incorporated in the rules till today. Entire procedure has been laid down in 2007 rules. In fact, that has been changed, amended. This amendment till today has not been incorporated. No notification till today, no government order even, a minutes of the meeting. And before that, no meeting with all the district authorities. And you'll also kindly go through the judgment. All points have been taken note of. It is an elaborate judgment, all points. And ultimately, resolution has been quashed and set aside. And that was the indication of the single bench also. Go and prefer a file a writ petition challenging the resolution.
This is amendment. This is what
But only one answer I shall show to your lordship. Kindly come to page 74. This is the board sheet 4, which has been provided to me under the RTI Act. The marks which has been given to me. Only one answer I shall show to your lordship. I got 43, that has been reduced to 39, that's apparent. There is no initial in the right hand side box. Kindly turn my lord page 84. Only one answer I shall show to your lordship. My question number 19. Bonganabodh korun. Most animals have their own particular habit. বেশিরভাগ প্রাণীর নিজের আলাদা অভ্যাস আছে. The examiner gives me 2. It has been reduced to 1.5. I don't think there would be any other Bengali or translation. Yes, Bonganabodh korun. Most animals have their own particular habit. বেশিরভাগ প্রাণীর নিজের আলাদা অভ্যাস আছে. Only one marks. There are so many particular, বিশেষ.
Not allowed. Like, particular means what? Not
নিজস্ব
alada, not a actual translation of particular.
নিজস্ব
It's a different.
বিশেষ
Different.
particular means specific বিশেষ anyhow my lord other questions are also like that to reduce to one
Five correctly done, not to
who has done it
whatever.
who has done it the same examiner no signature nothing no initial or either no all right but your lordship kindly see in not a single page there is any initial event whether it then my lord your lordship kindly have shown to your lordship so my specific case is that which has been considered by the I do admit my lord I have also some difficulties. So, my lord, admittedly, there was no meeting, which is the mandatory provision, took any resolution. The members of the Central School Service Commission conducted the meeting, took a resolution.
Not notified in any.
2 years back, not notified, not any government order, not incorporated in the rules. Only after examination, at the time of re-examination, they have used the same.
And actually, this is amendment. It is.
Power touch হয়ে যায়। Well, 2009, this regulation. Regulation and advertisement, kindly see, my lord. December 2011, after 2 years.
28 December. Examination after evaluation.
But two dates. But two dates are very important. The minutes of the meeting is, my lord, 31st December 2009. Advertisement, my lord, kindly say 28th December 2011. They should have recorded the same in the advertisement. Advertisement is silent. কি দেখছে এগুলো? কি দেখছে স্যার? এখানে ভিডিও নেই না? সাহেবরা কি করছে দেখা যায় ভিডিও থাকলে। আমাদের এগেনস্টে নেই, এগেনস্টে নেই। কিন্তু ওখানে পাওয়ার কিছু নেই। দেখাও দেখাও যা যা
Directives, this is directives, even directives or not. Resolution kept in their pocket.
Yes.
Two dates are very important according to my understanding. On page 58 is the date of meeting, 31st of December 2009. And the notification has been issued on 28th of December 2011, more than after two years. Notification last line says, recruitment shall be done in accordance with 2007 rules, ignoring the so-called resolution. But this resolution has not been taken note of at the time of advertising the vacancies. Only one judgment, settled principle. But paragraph 13. Inconsistent. This is also inconsistent to the 2007 rules. Your Lordship rightly pointed out that there is no negative also. It has not been permitted, paragraph 13, my lord. But the rules, although silent, it does not mean it empowers authority to put an embargo. Paragraph 13. Cannot.
Paragraph
13, 1-3. The sentence starts, apart from this consideration, we are unable to understand how the Director General could issue any directives which is inconsistent with the recruitment.
subordinate legislation, one cannot go beyond that.
Absolutely.
Contrary to this.
Yes. Beyond the scope of statute. 2007 has the statutory rules. This has no statutory force. By way of you are trying to amendment the rules by a meeting of the minutes. And that too contrary to the power given to you. You are relying a judgment which you have placed before the division bench saying that under 2007 rules, there is no provision for 2006 rules, there is no provision.
But it was to be conducted by 2007 rule.
What I want to say, my lord, they have relied on in their resolution. this judgment which has been placed before your lordship. No, what they want to say, students are coming, candidates are coming, saying that I am filing an RTI application, please forward me all the information. As if the first paragraph of the resolution says, many candidates are filing RTI application. Ultimately, they have not been provided any opportunity. They assume the power of review. But these are my submissions.
Consider this judgment at page 5.
Lordship, matter may be kept tomorrow, my lord, in the morning. Yes, your lordship.
There is some homework which I have also.
I have given.
Page 5. underline
Page 5.
This is reported judgment, 2001, come to the first page.
No.
Yes.
Reading 2004, volume 6.
Yes, yes, yes. That has been quoted. Just I am giving you. Yes, my lord. I got just in past day fallen from your lordship also. And that is also my case, that only whether it has properly been posted or not. That's only.
The morning there was some kind of a resolution or a rule was produced by one university.
Yes, your lordship.
And there was a distinction between a review and scrutiny. They specified what the Supreme Court has said.
Judgment of the citation to the beginning.
এটা ইয়ে হয়েছে, এটা কোট করেছে এখানে, এখানে কোট করেছে, এটা লিখে তাড়াতাড়ি লেখ, জজটাকে দিতে হবে। হ্যাঁ হ্যাঁ অবশ্যই। ছবি তোল, ছবি তাড়াতাড়ি কর। And all points have been elaborately considered by the learned single judge. ছবি তুলেছিস?
For you, you have to answer that what to do.
Rules, just I'm giving you.
This judgment.
But page 155 of the stay application, rules has been dealt with.
Look at that.
Page 154. The learned single judge considered.
This is my homework to go through it because you should not be taken on surprise if I rely upon something. Let us judgment of 22. Jurisdiction of the court to interfere in this matter.
দেখি অ্যাপ্লিকেশন আছে জাজমেন্টের আমাদের ক্ষেত্রে বলুন তো ভালো করে শুড নট ইন্টারফেয়ার বলছে কিন্তু ফার্স্ট তিনটে লাইন অন্য কথা বলছে
Paragraph 24 of this judgment.
paragraph 12 বললাম
To both the parties.
Distinguishing.
মানে পসিবলি মানে লাস্ট জাজমেন্ট
Goes both the ways.
yes
You may say the policy must stand on the basis of the regulation and
Yes.
the rules. It cannot depart.
yes
You must have a power.
yes
They say it is purely a policy matter. It is unconnected. to the-
but policy but who can take the policy
What I
who can take the policy
put for thought to both.
that's true but possibly মানে at the first reading it appears to me it's a court considered a policy
Listen, this is what they have taken. If they call it a policy decision, which they have taken, resolution is what? It's really a policy decision.
some members of the council
Conduct the examination.
it's not a policy of the state rules have been framed by the state act has been framed by the state some people of
Now, we do not want to express any mind. We have given you for
my lord
thought.
my lord my lord
Go through it.
Yes, your lordship.
Then
As per the convenience of this.
return it back after noting.
নোট করেছো ওটা
The first sheet you will find the reports where it is reported.
Yes, sir.
On the first page.
এটা নিয়েছিস এটা দিয়ে দেবো যার এটা তো না এটা নেই এটা নেই
Yes. When
As per the convenience of the court.
না না
you finish.
মানে instead of
Is the
day
reply
after
you have given, you have finished
day after tomorrow just day after tomorrow only one day
reply. You are not supposed to give reply to a reply.
I should be there my lord
No further clarification.
they have make it day after tomorrow
You should not be there. That's better for the page. Complete tomorrow. Reply to reply you will give.
no not me
Will not permit.
As your lordship. My junior will be there, my lord. Huh? Huh. But I'm handing over. So for the last judgment, as I understood, my lord, it is not applicable in my case, my lord. Everything has been notified in all those cases which has been fallen from your lordship. If that point,
Something struck me, that's why.
yes, yes. But if that point starts, my lord, then I shall be given an opportunity. So far, all right, I'm good. Tomorrow it will appear in the top of the list. আপনি থাকবেন দেখতে পারি
The bad habit of hovering around those points. Struck, then I have a bad habit of
marking.
No. Going through that, unless I am satisfied, I do not, like a lawyer. Bad habit of doing it. The seats of a lawyer.
It's 27.
My lord, in this, I'm appearing for the respondent, my lord, led by Mr. Supriya Chattopadhyay. Mr. Chattopadhyay is not feeling well. He requested me to pray before your lordship to fix the matter any day, Wednesday or Thursday or next week, any, subject to your lordship's approval.
Not today, let us see.
Not today and tomorrow then, my lord.
28.
28, my lord, I am appearing for the respondent number 3.
My lord, I am for the appellant, my lord. State is the answering respondent.
I am appearing for University Grants Commission led by Mr. Anil.
My lord, I appear for the state, my lord. Mr. Ganguly is leading me, my lord. May I pray for not to be
Ganguly who represents the state. It's only one Ganguly.
I'm sorry, my lord. Mr. Somnath Ganguly, my lord. My lord, may I
বলো জজ সাহেবকে বলো হুজুরকে বলো আমাকে বলছো
my lord.
Why?
Lord, Mr.
Every day it is a not today affair. What to do? Luckily today, some hearing matters, they continue. Otherwise, every time the not today is the routine feature.
তোর সিনিয়র থাকবে তো কালকে বসে থাকবে
Let us do one thing. We are starting. Let us say every matter, we will say it will be called at 12:05. Yeah. It will be called at 11:30 AM.
My lord, yeah.
It will be called at 10:35. Get a chance that it will be called at that time. So not today. Another court will not happen.
My lord, yes, from
My lord,
Can we adopt this? It's the innovative idea. Can we adopt this as a test case that your matter would be called at 12 noon? You can stop any matter continuing and then call that matter at 12 noon. If you suggest, no difficulty. What's the matter? Effective out of time.
44 days.
my lord, I have no copy.
I at the outset, my lord, I should
My lord,
say
I have no copy, my lord. My lord, give
the
me
copy
some.
has not been served
Yes,
to
my lord, served.
College Service Commission.
What?
All others.
Sir, copy na.
The copy, let the appeal and application be dismissed.
My lord, sorry, my lord. Only the one, my lord.
My
he
lord,
has been
respondent
left out.
number 3, my lord.
Other, my lord, actually, my lord,
Yes.
my lord, UGC and government has been served, my lord, and the commission has been,
Commission has,
because my,
we had not.
no, my lord, not,
It not be served.
no, my lord. This is my mistake, my lord.
That's the perception.
My lord, my mistake. No, my lord, my mistake.
They are not required to be heard.
No, my lord. My mistake, my lord. Commission has complied with, my lord, the order passed by the government, my lord. They are, my lord, their role, but be that as it may, my lord, it was my duty to serve. 44 days. Five is the only explanation, my lord. Paragraph 5. Amitabh was GP.
engagement.
Your client is a teacher.
Yes.
What subject she teaches?
She is the aspirant to the post of principal Milord of the Surendranath Law College.
Is what subject?
Law.
What subject she teaches?
Law, Milord. Law different parts.
I just wanted to know that's a civil
Object no.
I mean the IPC now, not IPC now. PSN what? PNS, not here.
Sangeeta. I
what the students do. Teachers, the students in a drowsy, I would say, a drowsy state of mind, then it's dangerous. Come to page 7.
Yes.
Line about 4 from the top. The applicant was not well. Read.
Yes.
And then drowsiness and he's feeling under medication or under drowsiness. Then thereafter
She had to discharge
he had
her duties at the college and she could not.
duties is to impart education in a drowsy state of mind. Because she was constantly facing the drowsiness. She was under medication. Not proper. Not proper.
The disclosure of truth and fact, Millard. Sometimes disclosure of truth and fact, Millard, both. And Millard, I knew, Millard, that this line, Millard, I was, Millard, skating on the thin ice, Millard, but still, Millard, I had to do it because that is the fact narrated to me. I was taking a risk by narrating this, but since I am a creature of the instruction of my client, I said that she was not feeling well at that point of time, but she said, drowsiness, Millard, your lordship knows certain medication, Millard, it has aftermath, Millard, it has certain, Millard, influence on the body and mind, Millard, both. But
drowsiness means it is not a correct state of mind because there are some kind of a extraneous force which really impedes the free flow of thoughts.
Millard, in a way, Millard, but there can be a different perception, Millard, that she was, Millard, at that point of time, Millard.
Dizziness. I just
Dizziness, Millard. Dizziness. Dizziness would be more better words, Millard.
You have used that.
44 days, Millard.
drowsy অবস্থায় গিয়ে তুমি পড়িয়েছো তোমার কাছে তোমার
Yes.
সময় নেই কি পড়িয়েছো সেটা তো আমি জানি will I believe that whether the first is correct or the second is correct
Dizziness is more appropriate, and that should be the choice of words. Kindly pardon our incompleteness.
Whose incompetence?
In no, I said incompleteness.
I think your lordship, my lord.
Deeply obliged.
This we cannot.
Why you know? Yes. For condonation of delay of 40.
उसको तोड़ाना क्या उसको
After
Hey.
was received
Honorable
by
copy.
after updating certificate copy, the draft was prepared, but she could not.
এই জেরক্স করে তোকে দিয়ে দিচ্ছে, অ্যাপ্লিকেশন আছে, জেরক্স করে দিয়ে দিচ্ছে। এখন
Application which she was undergoing.
Delay one day.
As sufficient for the purpose of the delay in filing the instant appeal is hereby condoned. The application being CBM by allow let the application
can 3 Millard. Section 5 is can 3 and can 2 Millard. Order this is Millard order 41 rule 27 Millard. I wanted to Millard use this additional evidence Millard.
let the can 1 and can 2 be listed on Thursday.
Deeply obliged.
Thursday.
Can 2 জেরক্স করে
I'm grateful, my lord. Thursday or Thursday.
I have a administrative meeting at
Yes.
4:35.
Yes.
Very careful.
The lordship has fixed on Thursday.
Who draft your junior?
But it is my responsibility.
No, but
My
who drafted? Junior?
My responsibility. I cannot say my junior has. When I take charge of the matter, it is my responsibility. Every fault is mine.
Instruction was on 11th. Application for certified copy on 14th. What you were doing for 3 days explanation? You have to either record in the meantime, the 12th being the Saturday, 13th being the Sunday, 14th on the first available date applied. First teaching from my senior was that when you are drafting section 5, the calendar must be on the side.
No.
Come tomorrow, next time.
Tomorrow and day after tomorrow, always personal visit, I want to come to them. But I will be accommodated short for me.
Yes.